building plan. Lordship, it is a matter of divergency, Lordship.
Motion.
Yes, Lordship, motion.
Hand over this. It's a hearing matter. Motion. Motion, please hand over the slip. Correction, hand over the slip. New motion, hand over the slip.
Motion, better, your lordship.
Hand
May I
over.
have your lordship's kind leave, my lord, to mention, my lord, two matters, my lord, for inclusion in the
Lordship.
list, my lord. Both the
Lordship,
matters were due to appear today, my lord, in the list. New motions, my lord.
New motion, please hand over the slip.
Lordship, I'm mentioning the two
Obliged,
matter.
your
One is regarding rectification in the order sheet,
Correction, please hand over the
and
slip.
also another one is for the is in the motion stage.
Motion, hand over the slip.
Much obliged, Your Honor.
Yeah, one thing I mentioned then last week it didn't come in the list. So Lordship,
Under what heading?
motion.
Hand over the slip. Hearing, please don't mention. Yes, please call the list.
Number one.
There is a short correction, my lord. Second page, third paragraph, my lord. 2017 instead of 2000.
Oh, 27. The final
27.
result of the examination was published on? Oh, 27. It was on 2017.
Yes, 17, 27. That is correct. Others.
The final result publication date is correct, 5th
Yes.
September 2017.
Yes.
Only the last date of final examination that has been wrongly.
Yes.
Learned advocate appearing for the petitioner submits that there is a typographical error in the second page of the order dated October 28, 2025, wherein in the second paragraph, the last day of the final examination of 2 years, D full stop E capital L small full stop E capital D small training course was recorded as January 18, 2027 instead of January 18, 2017. Let such error be rectified. This order shall form part of the order dated October 20, 2025.
Yes.
Yes, call the next matter.
My lord, for the petitioner, this is for correction, Lordship. Lordship, it has been written in the paragraph number 2 that it's an inter-district transfer, Lordship. So the board will be the party to consider. Respondent number 4, it has been said that chairman of DPSC Coach Bihar. So chairman DPSC, no, it would be the board.
My lord, I am appearing for the West Bengal Board of Primary Education, my lord. I may be served the copy of the writ petition, my lord.
Already
You
been
have
served.
not been served.
No, Lordship, it has been served. We
Please
have
serve a copy upon Mr. Bishwa's.
served, Lordship. We have also submitted the affidavit. But we'll serve again.
Mr. Bishwas, do you have any advocate appearing physically in the circuit bench?
Yes. I have, my lord. I immediately I'll
What is his name? Please serve it upon him.
Sure.
Him or her. The learned advocate appearing for the
Correction.
petitioner submits that since it is a inter-district or intra-district?
Inter-district, Lordship.
INTRA.
Ha, TER.
TER. That since the issue relates to inter-district transfer, the competent authority is the board and not the district primary school council. Full stop. Such submission is not opposed by Mr. Bishwas, learned advocate appearing for the petitioner, appearing for the board. Full stop. Mr. Biswas, you are appealing for the board.
My lord, for the board, my lord, the West Bengal, my lord, secretary, board is the, my lord, the authority to, my lord, consider.
Yes, board, yes. First up, in view thereof, the direction is passed upon the chairman.
My lord,
Chairman or the
secretary.
secretary?
Secretary.
The Secretary, West Bengal Board of Primary Education, being the fourth respondent, to consider the application for general transfer and to pass a reasoned order thereupon. Full stop. The order dated October 28, 2025, accordingly stands modified to the extent as indicated herein before. Most of other portions of the said order shall remain unaltered.
Grateful lordship.
Yes, next.
My lord, your lordship, my lord, directed the secretary to consider and, my lord, the pass a reasoned order.
Yes, to consider and dispose of.
My lord,
That
grateful.
direction was passed upon the primary school council. I have changed it to secretary board.
My lord, grateful.
Yes.
Three also for correction lordship.
What
This
is the
is also
nature?
transfer. Lordship, this is an upper high secondary transfer lordship. It's an intra-district transfer.
Yes.
The school name has been corrected. It says the normal section Patlakhawa High School. So the normal section won't be there. And lordship, in this matter, the commission.
Normal
Same.
section won't be there.
And lordship, the authority to consider is the commission, secretary of the West Bengal Central School Service Commission. In the last paragraph, it has been written that the secretary of West Bengal Board of Primary Education. So that has to be corrected.
Please kindly come to page 24. The representation, you have said assistant teacher, normal section, Patlakhawa High School. That's your representation, madam.
Lordship, then.
It's
Lordship,
your representation. In the representation, you have stated that.
then lordship, the authority to consider is the commission, secretary of the commission.
Secretary of the commission
Commission.
can be stated.
No, lordship, in the last paragraph.
Oh,
it
last
means-
paragraph,
yes,
Secretary West Bengal
of the
Board of.
Board of Primary Education. That should be secretary of the Central School Service Commission.
Oh, four. Oh, it should be the secretary of the West
Commission,
Bengal
lordship. Central-
Central School Service
Service
Commission.
Commission.
It has been pointed out that through inadvertence in the last paragraph of the order dated October 28, 2025, it has been recorded that the secretary, West Bengal Board of Primary Education, shall consider the representation and dispose of the same by passing a reasoned order. First of the learned advocate appearing for the petitioner submits that the School Service Commission is the appropriate authority. First up, in view thereof, the order dated October 28, 2025 stands modified to the extent by directing the Secretary, West Bengal Central School Service Commission, being the fourth respondent, to consider the representation and to dispose of the same by passing a reasoned order. First up, the order is modified only to the extent as indicated herein before. The other portions of the order shall be.
Grateful lordship.
Yes, call the next matter.
Oh, Lordship, as for the petitioner, my lord, this matter was heard in the earlier occasion by your Lordship. My lord, the wife, my lord, has been brutally beaten by the husband, who is in police force. My lord, the husband, my lord, the FIR has been lodged.
Yes,
But my lord, the husband has not yet been arrested, Lordship. I am
Where is the-
seeking
where is
for
the-
fa-
where is the advocate?
Lordship, I beg to appear for the state in this matter. Lordship, in the last occasion already
Yes,
submitted report.
what happened to the application for anticipatory bail?
My lord, that had not been disposed of.
Where is
Lord,
Mr. Aniruddha Bose, Biswas?
my lord, I
Has he
have,
come? I'm keeping at 1 PM.
One.
Please contact, ask him to come. একটার সময় রেখে দিন। Might be he's engaged there, trying to move his application there.
No, my lord, I will go, my lord. I will appear as a de facto complainant.
Yes.
Then number 5. Seven for the petitioner. 6 for the extension of interim order. But state is not a party here.
This is
for
not a party.
Not a party. This is for the extension of interim order. The last
Who is
extension was,
appearing for the labor commissioner?
this is the central level commissioner.
Who is appearing for?
Nobody has appeared since.
Respondent number 4, yes.
Respondent number 4, my lords, is the private respondent.
Private party.
5 is the workman. This, in fact, my lords, would be the 7th extension in the row. My request, my lords, would be, it may be taken up for hearing, my lords. Pending for quite some time, my lords. The workman is ultimately suffering, my lords. Last extension was given on 27th October, till the 30th, my lords. If at all, my lords, is extending the interim order, my lords, then let it be extended till the disposal of the writ petition. This is the 9th application we are moving.
While filing applications, it's not necessary to file applications. Only thing is that you have to have, mention for extension prior to its
What
expiry.
happens?
That you are not doing.
No, this time also we have filed the application before the expiry.
Why you don't need to file an application? Sir, I've directed all matters to be listed under the heading extension of interim order. If you have mentioned, you have not mentioned for extension of
Lords,
interim
let
order.
it be extended
Not
till the,
necessary file any application also.
I get that, lords. Let it be extended till the disposal of the writ petition.
The interim order is extended till the end of the month of February 2026 or until further orders, whichever is earlier. First up, list the matter under the heading hearing as directed by the order dated. Oh, it was directed on 1st of September.
Lords,
What did you do then?
this has
You did
long
not-
become a hearing matter, my lords. This is a hearing matter.
Yes.
Lords, may kindly take it up and dispose it of, lords.
List this matter under the heading hearing subject to the convenience of the bench.
In the month of.
Yes. Subject to the convenience. month is
इसको
difficult.
यहाँ कर देखें।
My lords.
Next. What was the application for extension?
Extension of interim order.
9. And what happened to the earlier applications?
All disposed.
All disposed of. Can 9 take a dispose of করে দিন? আচ্ছা দেখি, it has been submitted by the learned advocate appearing for the petitioner that application being can 2 of 2024, can 5 of 2025 and
इसको
can 6 of 2025
पूछना पड़ेगा।
has already been disposed of in the meantime. You have taken it up, can you dispose of it? In view thereof, the register
नहीं होगा कि
circuit bench is directed to see that the said applications are not shown to be pending in the docket of the circuit bench any further. Yes, next. Yes.
I am appearing for the respondent lordship. Actually, today only I got the online copy of the read lordship. So I pray for 1 day accommodation lordship.
My lord,
Yes.
traveling from Kolkata, my lord, so it will be difficult for me.
I have slightly gone through the read lordship. I can assist limited way lordship.
All right, because the learned advocate for the petitioner
Lordship.
coming from Calcutta, let
Lordship.
me see. Yes.
Lordship.
My lord,
Yes,
this is
Lordship.
very short matter, my lord.
Yes.
In this petition, the petitioner has challenged the order passed by the appellate authority. The appellate authority has dismissed the appeal petition filed by the petitioner on the sole ground of delay of 165
Where is
days.
the power of the appellate authority to condone the delay beyond the condonable period? Show me.
My lord, SK Chakraborty, the landmark judgment and following
The
that.
issue is pending before the August Supreme Court, sir. Has it been decided?
No, my lord,
Then-
but in another judgment of this of division bench of this Honorable High Court, it has been decided that section 107, the limitation prescribed in section 107 is discretion, is not mandatory. So, my lord, kindly allow me to share a copy of that judgment.
Yes.
My lord, from paragraph number 30.
Paragraph number
30.
30.
Direct paragraph 38 specifically, my lord. Thus, the intention of legislature to keep the said timeline under subsection 4 of
Paragraph?
38, my lord.
Yes, yes.
Thus, the intention of the legislature to keep the said timeline under subsection 4 of section 107 directory is evident from the contrary expression used in subsection 6 is self-same section if the legislature intended subsection 4 to be claused in
Yes, what is the period of delay in
my
this
lord
case?
165 days, man.
165 days after the condonable period, after 4 months.
After 3 months, my lord.
After 3 months is 165 days.
My lord.
So it's 135 days beyond the condonable period.
My lord, condonable period is 30 days after 3 months.
Yes.
So 120 days.
120 days. So you said 165 after 3 months
Yes,
is
my lord.
165 after 90 days is 135 after the
Yes, my lord.
4
Yes, my lord.
months.
Yes, my lord. Yes, my lord.
What is your explanation for the delay?
My lord, come to page number 35 of my writ petition.
Yes. Page 35, yes.
Yes, my lord. My lord, this is the screenshot of GSTN common portal. It is few additional notices and orders column of my GSTN common portal.
When it was uploaded.
My lord, it was uploaded on 9th October 2023, the date when the show cause notice was issued. Kindly turn up to page number 36 now. In order section of that additional notices and orders column,
No
there
records
is no
found.
records found.
And when you came to know?
My lord, in notices and orders in page number 38, they have suddenly uploaded the order in notices and orders column.
All right. So when you came to know?
My lord, after I got a telephonic call from the department on this August, I think. So they inquired me that whether I have filed any appeal or not. They will initiate recovery proceedings, and then I came to know that this show cause notice has culminated into an order, and then I checked this notices and orders column, and I.
Mr. Agarwal, what do you say?
Lordship,
There was no effective communication because it was uploaded in the additional notice and orders column.
Lordship, because he has not denied that he has not received the
No, that's
so-called
after the Mr. Agarwal. That's after the period. So after this period, because if the starting point with the date of communication of the order. So if the order was uploaded in another tab, not under the normal tab, can it be said to be due communication?
Lordship,
And
kindly
that
see.
also
kindly-
before, I think, 16th of January, Madam Sarkar, 16th
Lordship.
January 2024.
Lordship, kindly see the para 5 of page 5.
Para 5, page
Read-
5 of the writ petition.
Lordship.
Yes.
Your petitioner states that the so-called notice along with the GST DRC uploaded in additional notice and order section the GST and common portal. So the petitioner was the wrong impression that the order will be reflected in the same section GST and portal. That is under the view additional notices. Further, the order section relating to case number against which the so-called notice was issued. No document uploaded by the respondent. The respondent uploaded the impugned order separately under the view notice and order section because the order and because he has not disputed that he has not received the so-called notice within time, though it was in the additional portal. Anyway, Lordship, because Lordship have got the discretionary power to condone the delay for the appeal, let all the litigants should get the fair play. So my submission is that if
Yes, what have
Lordship
you
can.
tried to state in paragraph 5? It's confusing, sir.
My lord, on the GST and common portal, we also got confused, my lord. In additional notices on our orders column, the notice was uploaded. There the case ID was something. Against the same case ID, against the same column, under the heading ordered, there was no records found. So we got confused and
No, but you came to know in the additional notices and orders tab. So
that
you-
was uploaded in notices and orders tab.
Yes, so you
But
came to know
came
of
to
the
know
show cause
later,
notice.
but my lord. We came to know later, but as
When?
on
Which date?
my
You have
lord,
not said.
August
On August 14th.
13,
August 13th.
2024, my lord.
No, this is the telephonic call. Paragraph 5 is confusing, sir.
My lord, we also got confused, my lord.
Lordship, in spite of that, for the fair play, Lordship has got the discretion. Let him go to the appeal. If Lordship desire to invoke the discretionary power.
Yes, where is the order passed by the appellate authority?
My lord,
Show me that.
page 54, my lord.
54.
Starting from page 53 and 57 is the operative portion.
And where is the original order?
My lord, page 32, my lord.
Order passed under section 73(9).
My lord, my lord.
That order was passed after hearing.
After giving personal. Actually, the petitioner failed to participate in the proceedings.
Before the original authority also.
Yes, my lord.
Yes, Lordship.
Yes, Mr. Agarwal, no purpose will be served in directing the appellate authority to hear. Let it go back to the original authority.
Lordship, because he
Do
has
not
already
file the
paid
reply.
No, my lord.
Lordship, he has
Let it-
already because appellate authority now
Sir, Agarwal, I
discharging.
appreciate. Because
Lordship, Lord.
please consider one thing. The show cause notice, since it was uploaded in the additional tab, not under the
Lordship.
normal tab, he did not have the opportunity to file a reply to the show cause notice. So
Lordship,
he did not
I
have
differ.
any-
I differ there, Lordship, because he is not denying that he has not received the so-called notice.
No, Mr.
He is
Agarwal,
saying,
Mr. Agarwal, only one thing. Even if
Lordship,
I direct him to relegate him to the appellate authority, no purpose will be sought because there will be no reply to the show cause. What he will argue? So the merits is to be considered. So no useful purpose will be sought if it is relegated to the appellate authority. I think better
Lordship,
he has let him file the reply. Let this issue be decided once for all.
Lordship, here one problem is there because he has already filed the appeal and he has paid the 10% deposit. Now the appellate authority is also acting as the assessing authority because he doesn't have the power to set aside.
All right.
So
All right.
here
One
only
thing.
Lordship.
One thing, I'm relegating to the appellate authority, giving in an opportunity to file a reply to the show cause. Consider that and decide.
Grateful.
Lordship.
Thank you. Ashun. Where is the show cause notice?
My lord. Page. 25, my lord.
25.
My lord. ERC 01 is 24, summary to show cause notice, and show cause notice starting from 25.
This application under Article 226 of the Constitution of India is directed against an order dated June 23, 2025, passed by the Joint Commissioner, CGST and Central Excise within bracket appeal, Shiliguri Appeal Commissionerate. First up, by the order impugned, the appeal preferred by the petitioner was rejected on the ground that the same was presented after the condonable period of 30 days as per the CGST Act 2017. First up, paragraph. A show cause notice under section 73 within bracket 1 of the CGST Act 2017 was issued calling upon the petitioner to show cause as to why the demand raised in the show cause notice should not be paid by him. First up, petitioner did not file any reply to the show cause notice. No reply to the show cause notice was filed, and the proper officer under section 73 within bracket 9 of the CGST Act 2017 passed an order determining the tax, interest and penalty. First up, being aggrieved by such order, petitioner preferred an appeal under the provisions of section 107 of the CGST Act 2017. First up, since the appeal was presented beyond the statutory period of, since the appeal was presented beyond the statutory period of limitation, the same was accompanied by an application praying for condonation of delay. First up, the appellate authority being the Which respondent?
Appellate authority respondent number 1.
3.
Appellate authority respondent number 1.
Oh, 1.
One.
Being the first respondent, dismissed the said appeal on the ground that the same was filed after the condonable period of 30 days as per CGST Act, 2017. Paragraph. The learned advocate appearing for the petitioner submits. The learned advocate appearing for the petitioner submits that since the show cause notice was uploaded only under the additional notices and orders, double inverted comma tab, and not under the normal tab, the the petitioner was not aware of issuance of the said show cause notice, for which the petitioner could not file any reply to the said show cause notice. First up, the learned advocate appearing for the petitioner further submits that immediately after coming to know of the order passed by the proper officer under section 73 within bracket 9 of the CGST Act 2017, petitioner immediately thereafter preferred an appeal under section 107 of the CGST Act 2017. So he further submits that since for reasons beyond the control of the petitioner, no reply to the show cause notice was filed, an opportunity be afforded to the petitioner to contest the proceedings from the stage of filing reply to the said show cause notice. Paragraph. Per contra, Mr. Agarwal, learned advocate appearing for the CGST authorities, submit that the appellate authority lacks the power to condone the delay beyond the condonable period of 30 days.
Lordship, there is one, my submission is that he has not stated in the writ petition that he has not received the show cause notice.
I'm coming to that.
Lordship. And my submission is whatever the Lordship is saying that you have to, it has to be, the show cause notice has to be set aside. That can be done because the appellate authority has the power to pass the order confirming, modifying, annulling the decisions.
All right.
So,
where is that? Where is that? Which?
that is Lordship 107(11). Section 107.
Yes.
Subsection 11.
Yes. কি বললাম? And in support of such contention, he places reliance upon the provisions laid down in section
107
within bracket 4 of the CGST Act 2017.
11, Lordship, 107(11).
No, I'm coming to that, Mr. Agarwal.
Okay, Lordship.
Mr. Agarwal further contends that the petitioner has not stated that he did not came to know of the show cause notice from the additional notices and orders tab. So he further submits that since the petitioner was aware of uploading of the show cause notice by the respondent authority, no further opportunity should be granted to the petitioner to file any reply to the show cause notice. Full stop. Paragraph. Heard the learned advocates for the parties and peruse the materials placed. Where is that document which you said that in the website it was shown
Page
that no
35,
records?
man.
Page?
Page 36 in order section, it is no records found.
In notice section.
page 36, my lord.
Yes, in the notice section, there was no,
In notice section, there is a show cause notice.
where is that?
In page 35.
Page 35. This is under which tab?
Additional notices and orders.
Additional notices and orders.
Same case ID, my lord.
The heard the learned advocates for the parties and peruse the materials placed. First up, section 70, after going through the show cause notice issued under section 73 within bracket 1 of the 2017 Act, it is evident that an adverse decision was contemplated against the petitioner by issuing the show cause notice. First of section 75 within bracket 4 of the CGST Act 2017 states that an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. First up, since an adverse decision was contemplated against the petitioner by issuing a notice, by issuing a show cause notice under section 73 within bracket 1 of the CGST Act 2017, the proper officer was under a statutory obligation to afford an opportunity of hearing to the party prior to passing an order under under section 73 within bracket 9 of the 2017 Act, thereby determining 2017 Act, full stop, paragraph. It is not in dispute that the show cause notice was issued under the additional notices and orders tab and not under the normal tab. First up, the Honorable Division Bench in Ram Kumar Sinhal versus the State of West Bengal reported at 2025 177 taxman.com 48 within bracket Calcutta held that accessibility of the notice only under the additional tab as opposed to the normal tab could not constitute a proper communication or uploading as contemplated in section 73 within bracket 1 of the WBGST Act read with the concerned rules. First up, it is well settled that the period of limitation shall start to run with effect from the date of communication of an order, which is sought to be challenged in an appeal. First up, since the show cause notice was uploaded only under the additional tab as opposed to the normal tab, this court is of the considered view that such uploading under the additional tab could not constitute due communication of the show cause notice upon the petitioner against whom an adverse decision was contemplated. Full stop. Thus, to the mind of this court, the petitioner was prevented by sufficient cause for not filing any reply to the show cause notice. For such reason, this court is inclined to grant a last opportunity to the petitioner to file a reply to the show cause notice, as the same forms the foundation for the order passed under section 73 within bracket 9 of the 2017 Act. Full stop. The next issue that falls for consideration is whether the whether the appellate authority was justified in preferring an appeal beyond the statutory period of limitation. First up, you came to know only on
August 13th.
Telephonic call, Lordship, telephonic call of the department.
13th of August 2025. And when did you file the appeal? 26th of August. 26th of August.
Yes, my lord.
It has been specifically stated in the it has been specifically stated in the writ petition that the petitioner came to know of the order passed under section 73 within bracket 9 upon receiving a call from the office of the second respondent. Full stop. It is not in dispute that the appeal was filed on August 26, 2024, that is immediately after the petitioner received a phone call from the office of the second respondent. Full stop. This court has already observed that there was no effective communication of the show cause notice. Full stop. It is evident from the records that the petitioner was not aware of the order impugned before the appellate authority till August 13, 2024. Full stop. It is the learned advocate appearing for the petitioner places reliance upon the decision of the Honorable Division Bench in the case of Ram Kumar Sinhal in support of his contention that the
My lords, small indulgence, my lords.
yes,
My lords, may kindly go to the page 40 of the writ petition.
page
40.
40.
Yes, my lords.
Yes.
My lord, the petitioner has already submitted there that he has received this original order by email on 20th December of 2023.
Page 40.
Yes, my lords. He received the demand notice on 20th of December 2023.
Yes, you came to know.
Yes, yes, Lordship. That is also the
20th December 2023.
Lordship. That's why the para 5 is a very confusing, Lordship, as I pointed out earlier.
Yes, sir. What do you say? You are aware on 20th of December 2023.
My lord, but in proper section that was not uploaded, my lord.
What not in proper section? You came to know on 20th of December 2023.
My lord, through
Where is
email.
the reasons for the long delay till August 2024?
And that is the, he is saying the telephonic
Your
discussion, that is
application for
also after
condonation,
that.
you came to know. You have specifically stated.
Lordship, my the suggestion is that the show cause notice can be set aside and let him go, because if he has got the good case, so that is only the because litigant public should get the
Before
opportunity.
the appellate authority.
No, no, like show cause notice is the additional portal.
Yes.
So that's why. And
Alright.
another thing, I'm distinguishing the Ramkumar Lordship, because the Ramkumar, it is said, if the assessee is not able to see the notice, show cause notice in the additional tape, but
Yes.
here it is not the story. It is the story that he has received in the additional tape, but the final order is he has received in the other tape. So I like my findings, my submission may be noted that I like to distinguish the Ramkumar.
আচ্ছা তাহলে ওইটা লাস্টে কি বললাম? That the delay in that the appellate authority has power to condone the delay even beyond the condonable period. Full stop. Mr. Agarwal, learned advocate appearing for the revenue, seeks to distinguish the decision in the case of Ram Kumar Sinhal by contending that the said decision cannot apply to the case on hand, as the petitioner has specifically stated that he came to
He has
know
received the show cause notice.
that he has received the show cause notice on August. He's received the show cause notice. Full stop. Full stop. However, the fact remains that the petitioner did not file any reply to the show cause notice. Full stop. For such reason, this court is inclined to grant a last opportunity to the petitioner to file a reply to the show cause notice. Full stop. The order dated, where is the order passed under sections by the adjudicating authority?
My lord, page 32.
32. The order dated December 14, 2023, passed by the Superintendent CGST and Central Excise, being the second respondent, and the order of the appellate authority dated
No,
June 23, 2025, are set aside, subject to the condition that the petitioner shall file the reply to the show cause notice dated
Show cause notice 8 September 2020.
8 September 2023, within a period of
4 weeks.
why 4 weeks? Within a period of 3 weeks
3 weeks.
from the date of receipt of such, from the date of receipt of a server copy of this order, and if such reply is filed within the time limit mentioned herein before, the second respondent shall after considering the representation slash reply to the show cause determine pass orders in accordance with law after giving a reasonable opportunity of hearing to the petitioner or his authorized representative. Full stop. In the event the petitioner fails to submit the reply to the show cause notice as indicated herein before, this order shall automatically stand recalled and the writ petition shall stand dismissed.
My lords, the petitioner may not take unnecessary adjournment during the course of completion of the petition, my lord.
In case the reply to the show cause notice is filed within the time limit as mentioned herein before, the second respondent shall be authorized to refuse any prayer for unnecessary adjournments.
Grateful, my lord.
Deeply obliged, Lordship.
Yes. Call the next matter.
My lord, in item number 7, I am appearing on behalf of the respondent, CGST,
Yes.
together with Vishwaraj Jagora.
Yes, yes. What is this matter?
My lord, this is a matter of cancellation of GST registration for non-filing of return. Your lordship has passed order in.
Yes, Mr. Bonik, what do you say?
My lord, there was an order, but kindly have a look into page number 26, my lord.
Yes.
26 of the writ petition.
Yes.
This matter may kindly be considered because in para number 2.2, 2.3,
yes,
show cause notice, they have received the show cause notice, they have not replied, and they have not paid for revocation of the license. Never paid
The
for
Bonik, what
revocation
do
of
you
the
want?
license.
You want revenue or if you want to fight it out?
Yes, I want revenue. That is the
So,
all right, my lord.
so
My
if
lord,
this
my
is
lord.
rejected, will you get revenue?
All right, my lord.
Asun. Where is the order?
Yes.
This application under Article 226 of the Constitution of India is directed. You have also prepared an appeal.
Yes, my lord.
Yes,
What?
yes.
Belatedly.
Oh, belated.
Yes, my lord.
In all matters, you are belated.
No, my lord, different as
Yes, yes.
my lord.
Maybe.
But same
But all these
appellate authority, my lord.
all the persons who are making delay approaches you. I think one matter should be rejected.
No, my lord, kindly.
It will be started from this matter.
No,
This application under Article 226 of the Constitution of India is directed against an order dated August 6, 2025, passed by the Joint Commissioner, CGST and Central Excise within bracket appeals, Siliguri Appeals Commissioner, thereby rejecting the appeal preferred by the petitioner on the ground that the same is time barred. First up, the paragraph. The petitioner the registration of the petitioner under the CGST Act.
Yes,
CGST Act, my lord.
CGST Act 2017 was cancelled on the ground of failure to file returns for a consecutive period of 6 months.
6 months.
First up, the registration of the petitioner was cancelled by an order dated November 14.
February 1,
No, 1st February 24.
Where is the date of
my
the
lord,
order?
page 80. Order for cancel.
Was cancelled by an order dated February 1/2024
2024.
with effect from February 1, 2024. Full stop. Being aggrieved by such order, the petitioner has preferred an appeal which stood dismissed on the ground that the same was time barred. Full stop. Paragraph. Upon going through the order rejecting the cancellation of registration, this court finds that the same was rejected on the ground that the returns were not filed for a continuous period of 6 months. First of it is now well settled that under such circumstances, the an opportunity should be provided to remedy the breach. Full stop. The learned advocate appearing for the petitioner places reliance upon a decision of this court in past reliance upon an order. Placed reliance upon an order dated October 29, 2025, passed in WPA 1996 of 2025 in the case of Messrs. Jagat Bandhu Enterprise versus the Deputy Commissioner of State Tax, Shiliguri, and others. In support of his contention that the petitioner should be afforded a last opportunity to remedy the breach. First have heard Mr. Bonik, learned advocate, appearing for the CGST authorities. First up, this court, after taking note of the decision of the Honorable Division Bench, after taking note of the judgment passed by the Honorable Division Bench on April 9, 2024 in MAT 639 of 2024 in the case of Shubhankar Buldar versus Assistant Commissioner of State Tax, Srirampur Char and others. Allowed the writ petitioner, had set aside the order cancelling the registration of the petitioner subject to certain conditions. First up, the said decision shall squarely apply to the case of the petitioner. First up, for such reason, this court is inclined to allow the writ petition. First up, accordingly, the writ petition stands allowed and the order dated August 6, 2025, passed by the Joint Commissioner, CGST and Central Excise within bracket Appeal, Shiliguri Appeal Commissionerate, and the order passed by the Superintendent Raiganj, dated February 1, 2024, directing cancellation of registration are set aside subject to the condition that the petitioner shall file returns for the entire period of default, pay the requisite amount of tax, interest, fine and penalty within a period of 3 weeks from the date of receipt of a server copy of this order. First of, in the event the petitioner complies with the aforesaid directions within the time limit as mentioned herein before, the petitioner's registration shall under the relevant act shall be restored by the concerned jurisdictional officer. So it is however made clear that in the event the petitioner fails to comply with the direction within the time limit mentioned herein before, comma, the benefit of this order shall not inure in favor of the petitioner, and the writ petition would automatically stand dismissed without any further reference of this court. Paragraph, in order to ensure compliance of the directions passed herein before, the respondent authorities are directed to open the portal so that the return can be filed and tax, interest, fine and penalty can be remitted by the petitioner within the time limit mentioned herein before. Full stop. There shall be no order as to cost. The writ petition stands allowed with the aforesaid.
Grateful, grateful, man. My lord, my name may kindly be recorded. My name.
Your name, yes.
Yes.
Your name has also been recorded in the body.
Grateful, grateful, my lord.
Yes, call the next matter.
Mine.
Yes, what is this?
The petitioner is paying for permission to refund the employee contribution provident fund to get the benefit of the pension. Now, when the petitioner retired from service, he is the assistant teacher of Jalpaiguri High School, retired from service on 31st March 2006.
Sir, how long can it continue? You can come at any point of time.
As per 2003 division bench judgment, I am coming. 2003 division bench judgment.
Yes, now it's 2025. That is why I am asking you. How long it will continue? How long it will continue? You can come in at any point of time.
No, not point time.
So,
There. But kindly
when this will end?
This will end if the client is satisfied and get pension.
Yes, yes, I am asking you, when this will end? Judgment passed in 2003.
No, 2023.
So,
23.
yes, and now it's 2025. When have you applied for refund?
Well, I have applied, the commissioner is still pending my case.
When have you applied, I'm asking you?
I applied 2020.
20?
First, 2020.
No. After the division bank judgment, when have you applied? That is still pending.
Yes.
Where is that?
On page 15.
1-5.
1-5.
Yes, but you did not refund the government share at that point of time.
There is a yes, due to illness, I have not even at that time.
Why?
Well, due to illness, it is mentioned in my representation as well as petition.
Where is the representation?
14. 13, 14.
Yes, what do you say?
And 16, page 16. Page 16.
Page?
16.
1-6, yes. What does page 16 say?
There is another. Page 16 and page 18 is the order of the direction have been given upon the years. Like query and
so the DI has forwarded to the commissioner saying that permit to refund. So it was allowed, your pair was allowed.
DI was allowed, but DI did not calculate the amount till now.
Did not?
Calculate the amount.
Now it has been calculated.
No, till now not calculated.
So you calculate. So how long it will take to calculate? Again he will say, yes, it has not been calculated. Come tomorrow with the calculation. Ask the DI to calculate. How long it will take to refund the government share requested to permit? Ashwin. this application under Article 226 of the Constitution of India has been filed, praying for a direction upon the respondent authorities to grant pension to the petitioner upon refund of the employer's share of contributory provident fund from the date following her retirement from service and to release the area pension. The petitioner who was the petitioner who was an assistant teacher of Moinaguri Girls High School retired from service on March 31, 2006 upon attaining the age of superannuation. First up, the petitioner retired from service upon receiving retired from service na kore after retirement from service, the petitioner received the retirement benefits, including the amount accumulated on account of contributory provident fund benefits. First up, the petitioner also received gratuity as per the pension payment order issued by the concerned respondent authority. First up, the petitioner has approached the authorities praying for allowing her to exercise option to come over to the pension cum gratuity scheme from the contributory provident fund scheme. Full stop. The grievance, paragraph, the grievance of the petitioner is that the respondent authorities have not taken any steps pursuant to the prayer of the petitioner to allow her to switch over to the pension scheme from the CPF, C fullstop P fullstop F scheme. Fullstop paragraph. The learned advocate appearing for the petitioner submits that due to sudden illness of the petitioner, she could not refund the amount on account of government share of contributory provident fund along with interest and additional interest. First up, he submits that the petitioner is now ready and willing to comply with, is ready and willing to refund the government share of CPF along with interest and additional interest. Full stop. Paragraph. The heard the learned advocate for the state, the learned advocate appearing for the petitioner places reliance upon the decisions of coordinate benches on similar issues. First of heard the learned advocate for the state. Full stop. Paragraph. Record reveals that the district inspector of schools within bracket SE Jalpaiguri issued a memo dated December 17, 2024 requesting the Commissioner of School Education, West Bengal, to permit the petitioner to refund the government share of CPF along with interest and additional interest as admissible in terms of GO number 749-AC within bracket L bracket close dated June 13, 2024. Who is to compute this amount?
District Inspector Office, DI.
Uh, Then why did he write to the Commissioner of School Education?
Commission also.
Why? He is the authority to decide. Why did he send to the Commissioner of School Education? It is now well settled that a person willing to switch over to the pension cum gratuity scheme from the CPF scheme can be allowed to switch over to the pension scheme subject to refund of the government share of CPF along with interest and additional interest as per the now in terms of the GO dated June 13, 2024. Full stop. WPA number,
This letter was sent because Shukran, the big had, sent the letter to the DI on 3/12/24. This is why commission also.
written a letter 3/9/2020.
3/12/2024.
Oh.
Against the said letter, this letter. The same letter dated.
All right.
12/2020.
The District Inspector of Schools,
Secondary education.
within bracket AC, Jalpaiguri,
Yes.
Jalpaiguri, being the fourth respondent, is directed to calculate the amount required to be refunded by the petitioner to avail the benefits of pension within a period of, yes, how soon? Within a period of 2 weeks from the date of calculation, make it 2 weeks from the date of receipt of a server copy of this order, and to grant a reasonable time to the petitioner to deposit the said amount. Full stop. Upon deposit of the amount as directed to be deposited by the district inspector, by the fourth respondent, comma, the pension sanctioning authority shall verify the pension papers of the petitioner and shall send the same to the Director of Pension, comma, Provident Fund and Group Insurance, Government of West Bengal, being the which respondent? Fifth respondent,
Yes.
being the fifth respondent, who shall take further steps in accordance with law for issuance of pension payment order in favor of the petitioner. As expeditiously as possible, but positively within a period of 8 weeks from the date of deposit of the amount by the petitioner. Full stop. With the above observations and directions, WPA number such and such stands allowed. Call the next matter. Yes, what is this?
Matter my lord relating to transfer of a school teacher.
Transfer of school teacher.
Here, my lord, the application is pending before the school service commission. Since
School,
long, my lord.
School Service Commission, where is it? Where is the
My
document?
lord, my lord, I am appearing for the School
Last
Service
page,
Commission.
28.
If you, petitioner applied on medical ground, it is pending before the School Service Commission. Your lordships may direct, my lord, the Secretary of the School Service Commission to consider as per law. My lord. Since the Utshasri portal is now under suspension as per the,
It's a general transfer
my lord, on medical
Medical
ground.
ground.
on medical ground,
Yes, my lord.
medical and distance.
Two grounds cannot be clubbed together, my lord. It's medical ground.
This is my prayer.
His
As per
prayer,
rule-
consider it.
Yes. But
The petitioner who claims to be an assistant teacher in a high school has has applied for transfer on medical ground as well as on the ground of long distance. Full stop. The learned advocate appearing for the petitioner submits that the School Service Commission is sitting tight over the application filed by the petitioner praying for transfer. Full stop. Paragraph. Mr. Rai, learned advocate representing the School Service Commission submits that two grounds cannot be clubbed together in one application. Full stop. Paragraph. Be that as it may, since an application praying for certain reliefs has been filed before a concerned authority, such authority is duty bound to consider such application in accordance with law and communicate its decision to the applicant within a reasonable time. Full stop. In view thereof, WPA number such and such stands disposed of by directing the secretary
respond
or
number
the
4.
chairman,
Respond number 4. Respond number 4, Secretary.
by directing the secretary, West Bengal Central School Service Commission being the fourth respondent to consider the application. Where is the date?
My lord, it is an online application. Petitioner has made through Utshasri portal.
Always.
And portal is now suspended.
Filed equivalent to consider the, so where is the particulars which used to be?
My lord, page 30. My lord, kindly turns to page 30. Serial number 1. My lord, on 21st of September 2022, my lord, DI forwarded the application to the WBC SSC.
Page?
Page 30. 30.
No, he says page 28.
My lord, that is application, but my lord, the original my lord, status is page 30, my lord. From where, my lord, it can be ascertained that the matter is pending before the School Service Commission
no
after
30.
complying all the.
Page 28 is the last.
Oh, 28. I think there is a
Page 30 next.
page 28.
Here.
It is pending.
Yes, my lord, page 28. Yes, my lord.
Can I get the date? Where from I get the date?
Yes,
My lord, 29th of September 2022. 21st of September 2022. Serial number 1.
Serial number 1.
Oh, serial number 1. Oh, equivalent to consider
DI.
the application of the petitioner dated September 21, 2022 in accordance with law and to communicate the decision to the petitioner. Any opportunity of hearing is provided.
Is not required, my lord. Is not required, my lord. Since medical ground, my lord,
communicate the
commission.
decision to the petitioner as expeditiously as possible, but positively within a period of
6 weeks, my lord.
6
Total
weeks from
6
the
weeks.
date of receipt of a server copy of this order. Disposal of police now, which the above observation is disposed of. Yes, next.
Item number 10.
My lord, I am for this statement. I am for the petition.
Yes. What is this?
Same, my lord.
My lord, exactly
What
similar,
same?
my lord.
Which same?
Transfer
Transfer.
is pending before the school service commission.
Pending
Transfer
before the-
medical ground, yes.
Page 30.
Just, page 30.
Yes.
30.
What is the date?
21st.
21st September 2022. 2022.
Two.
You are the teacher of a high school.
High school.
Both transfer medical as well as distance. Same order. The medical fourth respondent. Secretary School Service Commission to consider. আগের মতো same. Application date same 21st September 2022. ঠিক আছে? Yes, next.
Grateful, my lord.
Item number 11.
Item number 11, my lord, service is not yet affected, my lords. None of the respondents.
What is this matter?
My lords, I am not in the matter, my lords. I have been informed, my lords, death in harness matter, my lords. Death in harness. I am not in this matter.
Job on compassionate ground, where? Bank.
Yes, my lords. Apparently, my lords, the Punjab National Bank.
When did he die?
My lords, I was just instructed by the advocate and record. I am not in this matter. Because if it may be placed before the next circuit, my lords, the service also will be.
The learned advocate appearing for the petition submits that service has not been effected. Must have been placed that this matter be placed before the next available circuit. Must have been viewed thereof, place this matter before the next available.
I'm grateful.
Petition is directed to serve a copy of this petition upon the respondents and file an affidavit of service. Yes, next.
I'm grateful.
Item number 12.
12.
Yes.
The transfer application is the primary teacher, my lord. And my lord, they are the inter.
Transfer application. Yes.
And my lordship.
Primary school teacher.
Yes, lordship already passed the order.
Primary school.
Yes. This one number 4, my lord.
Secretary.
West Bengal.
Board. Who is appearing for the board?
I am appearing, but I am appearing from item number 13 to 22. 12, I am not served.
12, you are not served.
Served upon.
Yes, Mr. Ghosh is appearing.
No, my lord.
Lord, I am assisting Mr. Biswas.
Okay.
Mr.
Yes.
Vishwas, your junior is present physically.
We order take.
Yes. Yes, Mr. Ghosh, you consider
Yes, my lord.
Secretary of the board
Yes, my lord.
transfer of the assistant primary teacher. এটা consider করবে Secretary West Bengal Board of Primary Education, fourth respondent. Corrective একটা order. Yes, next. Call the next matter.
13, I am appearing for the board.
This is also transfer.
This is also inter-district transfer matter, lordship, of your lordship's order. We have made.
Board is the appropriate authority.
Yes, lordship. Board.
Ghosh, you are appearing.
No, I am for the DPSC, Alipurduar.
Oh, you are the council. Mr. Vishwas is for the
Biswas
board.
is for the board.
So board is the authority.
Board is the
Yes,
authority.
আসুন ফাইলটা
Here is the clarification.
এটা
Lordship, we have made the necessary changes of your lordship's order.
নামগুলো দিয়ে দেয়।
board is the
My lord, the
secretary of the board,
secretary of the board.
fourth respondent.
Fourth respondent number
Disposed
4,
of.
lordship.
Yes, next. Call the next matter.
Similar matter, lordship.
Secretary of the board.
Yes, lordship.
Yes, my lord, yes.
Yes.
Up to 2022. Up to 22.
Up to 2022.
22.
22.
Yes.
All same.
All same.
All secretary of the board to consider.
Yes, lordship.
Yes, yes, yes.
Up to 2022, they can in. আজ একটা করে ডাকুন নাহলে মুশকিল হয়ে যাবে। Yes, এক একটা করে কল করুন, কত নম্বর দেখেছেন? 14 disposed of.
Sir, I want the state respondent.
15 APS service filing code to করে দেবে না? 15 disposed of.
নামটা দিয়ে
Call the next matter.
Same matter, my lord. Transfer matter, my lord.
15
Affidavit of service, my lord, or correction.
15 disposed of.
Same matter, my lord.
Lordship, I represent the state.
17 disposed of. Give your appearances. Call the next matter.
Same matter, my lord.
Disposed of. Call the next matter.
Same matter, my lord.
Disposed of. Next.
Same matter, my lord.
Disposed of. Call the next matter. This is also transfer.
Yes, my lord.
Board.
Yes, my lord.
Yes, yes, my lord, transfer matter.
Same matter.
8 to 20.
Disposed of. Next.
8 to 20. Ah. 21. 8 to 21. Same matter, my lord.
Disposed of. Next.
My lord, same matter, my lord.
Disposed of. Same order. Next.
Grateful, my lord.
23, I am for that petition. No, but I am for the petition.
Yes.
My lord, this GST matter, my lord. Here I am challenging, my lord, the recovery notice, section 73 order, audit under section 65(6), and first adjudication under section 74.
Principal bench is not, is closed today.
No, my lord, there is my item 30.
Principal bench, Mr. Majumdar, it's not functioning.
Function.
Seems it's not function. Stalwarts are here of the revenue side. Yes.
But here I am challenging the bank attachment recovery notice, section 73, second order, audit under
আমাদের কিছু নেই তো?
section 5, subsection 6, and first adjudication order under section 74. What happened, my lord? For the period.
You have preferred an appeal.
No, my lord. I'm saying, my lord. I'm saying only 2 minutes back, my lord. 2021.
It's an appellable order.
No, my lord. What?
It's not an appellable order.
Yes, appellable, but, my lord. Only 2 minutes, my lord. First adjudication order passed on the ground of mismatch 3B 2A under section 74. 74 is not applicable. I am coming on that part later. Thereafter, they passed the order on same subject matter, same period, same case, audit issued. Audit cannot be issued after the completion of the adjudication. Thereafter, again issued section 73 notice, because audit section 65 subsection 6 says if the audit amount not paid as per the audit observation, then it will convert in the show cause notice. In the second stage, though the proceeding is completely illegal without jurisdiction, but invocation of 73 is correct, because there is mismatch of ITC. 74 is not applicable, but the show cause notice issued. In between, before issuance of show cause notice, summon issued. But prior to that, prior to summon, all the proceeding not awarded by the petitioner. After receive the summon by speed post, then he submitted reply and admitted that there is mismatch, so I am paying the taxes. He paid the taxes on 12th September 2025. Same day reply submitted, and during this proceeding, same day bank attached. But that was not known. That was known.
But according to you, you have paid the entire amount.
Yes, but for the second stage. But at that time, the first adjudication order was passed. That was not incorporated in the second SCN, but that was incorporated in the second order. From the body of the second order, it is clear that No. There is the order of the 9th December 2024. As per the tax already paid. So now the interest and penalty will be followed from that 74 order. Now, there is also big violation, great violation, because I am assessing under section 73, their penalty is 10%. He is accepting that yes, this is same, but the penalty of 74 is not applicable here. So in my little understanding, my lord, entire both proceedings should be remanded to the adjudication and fresh show cause notice issued under section 73, because for ITC mismatch, there should not be in the under section 74, because 74 is fraud, willful statement. I will submit, my lord, three judgment on that issue, my lord. My lord, kindly have a look, my lord, 74, my lord. May I read, my lord?
What is the order which is under challenge? Show me that.
My lord, I am challenging entire proceedings, my lord. The first order, my lord. First order is starting from page 89, my lord. Starting page 74, my lord. The subject mismatch 3B and 2A. So this is not for, because they admitted in the second adjudication, there yes, 74 not applicable, 73 applicable. Operative part form 95. Mismatch of 3B and 2A, my lord, ITC. Not under the 74. Thereafter, my lord, they issued summon, my lord. There is no whisper, my lord, that how fraud committed.
No, but you were given an opportunity to.
Yes, because all that, my
So
lord.
did you appear?
No, because
Why?
this is my fault, because I depended on a tax consultant and all the notices.
What have you done to the tax consultant?
No, my lord, I'm the all the notices uploaded in
From
the
which profession he belongs to?
No. In the first stage, my lord.
What steps have you taken against the consultant?
My lord, he is the tax consultant, but latter part participated by the advocate. But first part not advocate, only tax consultant, not chartered accountant.
It's very easy to put the blame on consultants.
No, not.
And thereby changing the consultant, appointing a new one.
My lord, I'm submitting, my lord. But all the notices uploaded in the additional tab, that is why miss. But after receipt of summon.
When it was uploaded in the additional tab?
My lord, on 8 July 2024, after the 16 years.
Yes.
So I accept it.
So after 16th of January, it can be uploaded. It's available in the same page.
But my lord, but what happened in here, my lord, missed, because my lord, the portal.
That cannot be a ground.
No, I'm not submitting. I'm not
fight.
submitting. I'm accepting my fault. I'm accepting my fault, my lord, on that point, because
Please prefer an appeal. Please prefer an appeal.
My lord,
there is no
then my lord,
second natural justice.
My lord, then
otherwise the provision of appeal will become infractions.
My lord, then my lord, second order should go, my lord.
Whatever, challenge everything. Challenge everything.
My lord,
in the appeal.
no, my lord. I have to file. Then I have to file two appeal, my lord.
That you are not given opportunity. Opportunity was given, you did not avail of that.
My lord,
now you are coming. Please set aside the entire thing. No,
my lord.
Prefer an appeal.
I'm accepting.
The pre-deposit amount, yes, contest that.
I'm accepting, my lord. But problem is that second order should be set aside, because I cannot file two appeal against the two order for the same period, same case. This is the problem. Either first order or the second order. Either first order should go or second order should go.
What? Show me what are the two orders.
Yes, my lord. Yes.
Show me.
Thereafter, my lord, they issued summon, my lord. Just small.
Show me the two orders.
Two orders.
Thereafter, I will come to this.
Yes. Second order, my lord, page 161.
161.
161. Same issue, my lord, same. P20. And operative performs 162, my lord. The discrepancy is ITC 3B mismatch 2A.
This is the first order.
This is the second order.
This is the second
Last order.
Where is the operating part?
Operating part, my lord, 166, my lord. Last page.
Starts from 165.
165, last line, my lord. May I read, my lord? They participate in the proceedings.
No, after
না আমি বলছি স্যার আমি ক্লিয়ার করে দিচ্ছি আমি কারো ফেভারে বলবো না আমার যেটা অ্যাকচুয়াল সেটাই বলবো
তোমার ফেভারে তো বলো।
না 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 আমি অ্যাকচুয়ালটাই বলবো This is under section 73, my lord.
this case is dropped.
No, this as the tax paid.
166, it has been, yes.
Yes, but the line, kindly have a look, my lord, line. In the now it appears from the record. Another
Where
enforcement
is it?
case.
Which portion?
My lord, third line.
Third line at page 166.
166.
Yes.
Now, if it is very important.
Now, yes.
It appear from the case record that another enforcement case was initiated particular RTP where the case has been transferred to adjudication later. Also, final order has been passed. Same issue, same period, with reference number such and such. But that was section 74. That is not mentioned here. 74 from the record. Though some
other issues were also.
No, this is not. There are no other issue. I will show you from the record, my lord. No other issue.
As the tax component has already been considered in the said order.
Said order and has been assessed.
The undersigned is
So opinion that no further interest penalty should be imposed in instant case. But the interest and penalty, my lord, as per 74 already attached. But as per 74 order, he is accepting the tax.
This case is dropped. This case is dropped.
My lord, case is dropped, but
yes,
relying that interest and penalty is
whatever
charged.
it might be, the effect
That
is
means
that this case has been dropped. Where is the other order?
yes, my lord.
That's 65.
Only 65.
No, no, no.
65.
Starting page
Yes, only 65.
Starting page 89 and
89.
89 the starting page.
Sorry, 95. Sorry.
95
95.
from the middle portion. Mismatch of 3B and 2A.
So this is the comprehensive order.
No, my lord. Once, my lord, after 74, there cannot be first law point is that, my lord, after the passing of order.
Law point is on also on facts.
Yes,
For an appeal.
My lord, then, my lord, second order by audit report.
What is the second order?
My lord, second order, the kindly appreciate. I may wrong, my lord. I may be wrong.
What is the second order?
Second order, my lord, written that interest and has been assessed, but when
Page
166, my lord, that line.
That is your place. Now, please kindly come to page 95. Second order, the case is dropped. That's the ultimate finding.
No, my lord. Here, my lord, the case is 74. Again, the audit report, my lord. The audit completed the audit. Kindly have the audit report, my lord. This is correlated. Audit is correlated with that second order, my lord. Kindly have a look, my lord. 134.
Sir, if the nature of the order is an appellable order, the discretion is left with the court to exercise it or not.
My lord, I am accepting, my lord.
You have to advise your client which order is to be challenged or not in appeal, comprehensive appeal or not.
But
Not
it
under
will get
226.
my lord, a problem, my lord, because 73 order saying.
For that you are there to resolve the problem.
No, my lord. The line is that when the assessment completed, then interest, there must be interest. And there
So
must
second case, page 166, the entire case is dropped.
drop, but the interest and penalty relied on the 74 order. That is my
Maybe
contention.
that case has been dropped. You have to advise which order is to be challenged. Ashun, in view of the alternative efficacious remedy available under the statute.
My lord, bank attachment may be lifted, my lord.
Please prefer an appeal, approach that authority.
And my lord, the
In view
appeal
of
shall
the
not be
alternative
rejected, my lord, on the
efficacious
ground of
appellate
limitation.
remedy available under the statute, this court is not inclined to entertain this writ petition as various factual and legal issues have been raised therein. To stop with the WPA number such and such stands dismissed with liberty to the petitioner to avail the alternative remedy in accordance with law.
My lord, as the tax amount paid, my lord, that may be recorded. Tax amount.
Deposit.
No, PWC is not required because 100% tax paid.
Say so before the appellate.
My lord, kindly
authority.
record that. My lord.
Tax has been the
And
learned
my lord,
the learned advocate appearing for the petitioner submits tax has been recovered, not paid.
No, paid. My
Submits
during
that
proceedings paid.
that in the meantime the petitioner has paid the amount has paid certain amount of tax.
100% of tax.
Has paid the 100% of the tax, and therefore the petitioner may not be required to put in the pre-deposit as a condition precedent for entertaining such appeal. Full stop. The petitioner will be at liberty to draw the attention of the appellate authority with regard to such fact, and the appellate authority is left free to pass orders accordingly.
Appellate authority shall not reject the appeal on the ground of limitation, my lord, because otherwise.
When this writ petition was filed?
My lord, writ petition filed, my lord, after on 28th October, my lord.
28th of October.
October.
And what is the period of limitation?
Limitation, my lord, 3+1.
It expired prior to the filing of the writ petition, or it was
Expired, my lord.
it expired.
Expired. And one of the
Considering the fact that the petitioner has challenged the orders impugned by preferring a writ petition, which 28th of October is just now. I also cannot say it's pending for a sufficient long period of time.
No. Because, my lord, the date of knowledge of the after in the month of August, my lord, in the summon proceedings.
File an application directed to consider it sympathetic.
My lord, what, my lord? Bank attached.
But
my lord.
Mr. Chaudhary will reject it on the
Reject, my lord,
ground
reject.
that it is beyond the condonable
They
period.
will reject.
Again, he has to approach this court.
My lord, that will consider it. Kindly, my lord, that.
I'm allowing this. Ki bolna? Before this, before this court, the appellate authority is directed to consider the appeal on its merit without dismissing the same on the ground of limitation if such appeal is presented within a period of
3 weeks, my lord. 10 days. No, file করে দেব। 3 days. আমি 7 দিনে ফাইল করে দেব। 3 দিনে করে দেব।
within a period of
3
weeks
3 weeks, my lord.
from the date of receipt of a server copy of this order.
My lord, bank attached, my lord, same day, my lord. Once one appeal.
No, when I'm not entertaining the writ petition, I cannot pass an interim order.
We have served copies upon the answering respondents.
Who is the answering respondent?
The income tax department.
Who is appearing?
Well, that I
Mr.
do not know.
Singhania appears. Where is he?
No, DSG, the DSG told me, that DSG just now told me that he's not appearing in income tax and GST matters, just now.
I think Mr. Singhania appears.
But
because
my lord,
I've seen in the last circuit, he appeared in income tax matters. Mr. Mujumdar, what is the issue?
Well, I tell you, lordship,
Because ex party, it's
Well, may I just indicate to your lordship what is the issue involved? My lord, we are in this writ petition, we are challenging two orders. Orders disposing of preliminary objection as to assumption of jurisdiction under section 201, 2011A, and another order under section 271C. Your lordship knows better than us that these orders disposing of preliminary objections are not applicable orders, admitted. So we are challenging these orders before your lordship, and a pure question of law arises for consideration in these matters. The petitioner before lordships is the distributor appointed by organizing state under the Lotteries Act. Namely, my lord, state of Sikkim, state of my lord, Nagaland. And my lord, these distributors are not responsible for distributing the prize money to the prize winners. The law requires, on a careful reading of the provisions contained in section 194B, that is the provision for deducting tax at source in case of lottery winnings, the law requires that person who is actually responsible for paying the money to the prize winner would deduct tax if the prize money exceeds 10,000. The period involved in this year, in this case, is the financial year 22-23. 2022-2023. Now, my lord, an amendment was brought about with effect from 1/4/23, whereby, my lord, may I just indicate to your lordship, suppose
so it's after that period.
Is after that period. They have invoked
no retrospective effect.
No retrospective. That has been invoked. And your lordship knows that for TDS, the relevant period is the financial year. But the most important aspect is that whether a distributor can be considered as a person responsible in terms of section 204 of the Income Tax Act for making payment of prize money to the ultimate prize winners.
Because he is only distributing.
He is only distributing, and there is a chain, there is a distribution chain. And the relevant rules made by the state governments, namely Nagaland, government of Nagaland and government of Sikkim, says that the distributor through its distribution chain, well, actually the retailers make the payment to the prize winners. So retailers would be primarily responsible. Only the distributors, my lord, if they do so, my lord, they would be allowed to my lord, make payment of this prize money up to an amount of rupees 10,000, for which tax is not required to be deducted at source. Clearly spelled out in the rules. And any amount, whether, my lord, which exceeding 10,000, whether in aggregate or a single transaction, my lord, the state government would be responsible. Actually, my lord, the entire system, my lord, it goes back to the state government. Ultimately, my lord, the prizes are disbursed by the state out of the state exchequer. My lord, it is a kind of credit and debit arrangement worked out between the distributor, the sub-distributor, then, my lord, the retailers, and at the top, my lord, at the top of the chain is the state government. So, my lord,
so according to you, it's the state government.
It is relevant, my lord, the appropriate state government. It
Yes.
may be state of Nagaland, it may be state of Sikkim. So, my lord, at present, my lord, what we are apprehending, why have we come to this honorable court? Because, well, now they are now proceeding.
State of West Bengal is not involved.
But state of West Bengal is not involved.
So how come this,
But
this
the
court
income,
gets the jurisdiction?
Income tax department, Siliguri.
Yes.
Well, we are not concerned with the state of West Bengal at all. Well, the lotteries, though, well, state of West Bengal permits lotteries of other states to be, tickets of other states to be sold. But, the state of West Bengal is not at present organizing any lottery. At present, not organizing any lottery. But, the sale is made within the territory of West Bengal of the tickets of, Nagaland lottery and Sikkim lottery. So, it is within the territorial jurisdiction, and in fact, the jurisdictional officer who has passed these orders is the respond number one, that is, my lord, the Deputy Commissioner of Income Tax TDS, Ayakor Bhavan, Matigora, Shiliguri.
It's within jurisdiction.
In fact, my lord, for the relevant period, for the assessment year 23-24 corresponding to the assessment financial year 22-23, my lord, the assessment has been made by, my lord, the jurisdictional officer of the Central Circle, Kolkata. So, my lord, this court has jurisdiction. There is no difficulty to that. My lord, I am seeking some protection at the level. To the extent, my lord, even if they want to proceed, let them proceed, but no order should be passed. If final order should be passed.
Who appears
My
for
lord, that
the-
I do not know, my lord. We have served, my lord. My lord, Lordship, kindly act to equitable service to justice.
So Mr. Singhania has come.
He has.
Can you ask
He was
Mr.
sitting in the
Singhania to
court.
appear? He's still in the panel. Ask Mr. Singhania. Where is the order which is?
My lord, that is at page 679. Kindly take the last volume, my lord.
679.
Because, my lord, only the documents, everything has been annexed. My lord, they have prepared the paper.
What is the object of making this restriction voluminous?
But
Mr.
perhaps they
Majumdar?
thought, my lord, they have brought a heavyweight counsel physically. That is why they have got 800-page petition. But it's a question of physical heavyweight, nothing more.
679.
Kindly take, my lord, there are two orders. One at page 679, that is order made under disposing of preliminary objection so far as section 201, 1 and 1A is concerned, and another is, my lord, and 683 is identical orders, my lord. 679.
So you have raised the issue of jurisdiction.
Yes, we have, and that has been disposed of, rejecting our preliminary objection. Your lordship will find from the top sheet of the subject, disposal of preliminary objection.
Yes.
My lord has got that. Okay. Filed against the notice under section 2011 and 2011A of the Income Tax
Where is
Act.
what are the objections which you have raised? Please show.
My lord, that your lordship will find from page 635.
See, no, it's not recorded here.
Yes, it is
You
recorded.
can show it from here.
Yes, my lord. Kindly, may I just take your lordship to the relevant part? In fact, it is very interesting. I am taking your lordship from the third paragraph. Fourth paragraph.
679.
679. Fourth paragraph.
Yes.
Accordingly, a show cause notice was issued dated under section 201-2011 of the Income Tax Act, dated so and so, seeking explanation as to why it should not be treated as an assessee in default. Under section 2011 and interest under section 2011A should not be levied. In response to the show cause notice, the assessee filed his objection in the written submission filed on 9/8/2025 and in hearing dated 14/8/2025, which has been considered and is accordingly disposed of as discussed hereunder. At the outset, it is pertinent to note that in the hearing conducted on 14/8/2025, the assessee was specifically required to furnish a copy of the contract entered into with the respective state government in order to substantiate its claims and to clarify the exact modus operandi of the operations. However, despite opportunity, such agreement has not been placed on record.
You have not produced the agreement, Mr.
But that is not relevant. My lord, kindly take, my lord, second part.
All right. Yes.
On responsibility versus authorization. This is my objection. The assessee has argued, although it is authorized to disperse winnings up to 10,000, the
You are
responsibility.
the distributor.
Yes.
So according to you, you have you can only disburse up to 10,000, which is tax free.
Which is tax admitted.
Or in other words, there is no requirement to deduct tax at source.
Straight away, my lord, I take your lordship straight away to, my lord, just 1 second. Kindly take page 729 of the same paper. Kindly take page 729 of the same paper book.
Yes.
This is the, my lord, the Nagaland rules. Now, my lord, kindly take, my lord, straight away come to.
Here it's Nagaland is the state.
Nagaland is one of the states, Sikkim is another state.
Yes.
Kindly take, my lord, rule 12. Rule 12.4. 738. 738. Kindly take rule 12.4.
12.4.
The government may authorize the distributor along with his distributor network in the agreement to make payment of prices on its behalf up to rupees 10,000, to which income tax will not be deducted at source. As per Income Tax Act, to the prize winners within 30 days from the date of draw, the distributor shall not be allowed any additional charges for the payment of prizes. The distributor shall also not be allowed to charge any additional cost for distribution of prize money to the winners. Now, let us kindly take now sub-rule 9 of Rule 12. All claims of prizes above rupees 10,000 shall be submitted to the director along with a claim from director of state lotteries, obviously. Claim form as may be specified by the director from time to time duly filled in. Original prize winning ticket duly signed by the claimant on the backside of the ticket so and so so and so. However, if the claim for small prizes up to rupees 10,000, it can also be made directly to the director, but alternatively to the retailer, that is the distribution network. And sub-rule 10 says, in case an individual makes multiple claims for small prizes up to 10,000 in a single fiscal year, and if the total amount exceeds 10,000, tax will be deducted at source in accordance with Income Tax Act 1961. So, my lord, whenever, suppose a person wins 5 prizes, the cumulative effect of which that he is winning in excess of 10,000. Then also, my lord, whatever, my lord, the deductions are to be made. Either it has to be made by the retailer who is distributing the prize money, or, my lord, the state government who is ultimately the ultimate disbursing authority. My lord, the law, namely, my lord, neither the Nagaland State Lotteries Act rules, regulations, nor the Sikkim. I have also got the Sikkim.
How this has been dealt with?
Kindly take, my lord, now, kindly come back to the order. If your lordship comes back to the order. But this is very interesting because, my lord, what they're doing, they are reading something into the provision which is not permissible in fiscal jurisprudence. Kindly take, my lord, on responsibility versus authorization. The assessee has argued that although it is authorized to disburse winnings up to 10,000, my lord's got that? I'm sorry.
Yes.
The responsibility for paying price rests with the state government. The contention is misconceived. Section 194B of the Income Tax Act mandates deduction of tax at source by any person responsible for paying to any person any winnings from lottery exceeding rupees 10,000. The Honorable Supreme Court, he relies on CIT versus Eli Lilly and Company versus CIT versus Eli Lilly. This is 312 ITR 225. Held that the obligation to deduct tax TDS is upon the person who actually disburses income regardless of whether it is acting as an agent or principal. So, my lord, the law recognizes, even, my lord, this authority also recognizes the fact and the position of law that only the person who actually disburses the amount would be the person responsible for paying the amount and thereby deduct tax therefrom. My lord, it is a fact. My lord, I am not actually. Now, what is the rationale? The rationale is like this, my lord. Kindly take, my lord, for once. Therefore, once the assessee distributor disburses winnings, it assumes the role of person responsible for paying under section 194B, read with section 204. The distinction between authorization and responsibility is irrelevant for the purpose of TDS reduction. The assessee contends that the payments are adjustments so and so, so and so. Now, my lord, kindly come to this part. Kindly come to page 681. What is the real logic for fastening the petitioner with this liability, which is otherwise not authorized in law? Kindly take 681 first paragraph, where, my lord, the authority considers my objections on section 194 and 204 interpretation.
Yes.
The assessee being a principal distributor of lottery tickets and a central link in the price distribution chain clearly falls within the definition. How is it possible? I put the question to myself with all humility. It is not at all possible.
Says recognizes that though there is no direct.
So, my lord, now I tell you, lordship, there is a provision in the, my lord, in this scheme of act. Suppose section 194H. 194H clearly says that directly or indirectly it can be done. So far as my lord 194B is concerned, there is no such provision. Kindly compare section 194H. Income Tax Act Judge Sahib ke din. Or my lord, we have the copy, my lord. Kindly take, my lord. Then I will show directly from section 204 itself.
Yes, what happened, Mr. Singhania has been informed.
Yes, yes. He's arguing a matter in court number 4.
Kindly take, my lord.
Where is his juniors?
My lord, lordship is looking at 2025.
2025, 2026.
My lord, your lordship would have to look at the law.
Previous, because this
Because, my
contains
lord,
the
what has
amendment.
happened, my lord, there is this that kindly take, my lord, 194B first. B. Kindly take first 194B. Eta Judge Sahib ke dao. My lord, kindly take this book, no problem. I have got my copy.
Okay, is there?
Yes, yes.
So 194?
B. These are the relevant provisions.
Yes.
The person responsible for paying to any person any income by way of winnings from any lottery or crossword puzzle or card game or any other game of any sort or from gambling, etc., of any form or any nature whatsoever, being the amount or aggregate of amounts. But here they use the term aggregate of amounts. But exceeding to 10,000 rupees during the financial year shall at the time of payment thereof deduct income tax thereon at the rates in force. So, my lord, kindly take, my lord, this aggregate of amounts was introduced. Your lordship will find it was introduced with effect by the Finance Act 2023 with effect from 1/4/2023.
Yes.
Your lordship will find, man, that is there. Now, my lord, this is 194B. The next relevant provision is section 204. This is, my lord, where, my lord, the person responsible for paying has been defined.
Yes.
My lord has got that?
Yes.
For the purpose of the foregoing provisions of this chapter and section 285, the expression person responsible for paying, my lord, kindly come to III. The
Yes.
rest are not relevant.
Yes.
In case of credit or as the case may be payment of any other sum chargeable under the provisions of this act, the payer himself or the payer, if the payer is a company, the company itself, including the principal officer thereof. This is one. And also Roman 4. In case of credit or as the case may be, payment of any sum chargeable under the provisions of this act, made by or on behalf of the central government.
So according to you, it falls within 4.
It doesn't fall within either 3 or 4.
It does not fall
Because, my lord, it is not exceeding 10,000. Whenever I am making payment, the law doesn't require me to deduct TDS on amounts, my lord, not exceeding below 10,000. And, my lord, if it is an aggregate of amount, my lord, the law says for the relevant period, suppose the aggregate of amount.
So according to you, 204 is not applicable.
Not applicable. I do not fall within the definition of person responsible.
That will apply if it is in excess of 10,000.
Yes. And, my lord, kind and to top it all, this is in relation to financial year 23-24. 2023. But, my lord, the amendment has been given effect from 1/4/2023. I took this point before the assessing officer. He says, no, these amounts are increasing, so I am required to do so. Since the cumulative amount, suppose, my lord, somebody has won 10 prizes, 3,000, 4,000, 5,000, etc.
Where is how this point has been dated?
Kindly take, my lord. Kindly come back to the order.
Yes.
Kindly take, my lord. Kindly take, my lord.
SLP is also pending.
My lord, SLP is pending regarding, my lord, what happened. The file of the petitioner was with, my lord, the income tax file of the petitioner was with Chennai Circle.
For transfer.
But 127 order was passed. Your lordship knows. Now 127 order, my lord, the petitioner failed before the Madras High Court. Both before
Against that SLP.
Against that SLP has been filed, and SLP there is a protective order has been passed. And, my lord, coincidentally, my lord, the SLP, the assessment for the period is, my lord, AY 23-24, which corresponds to, my lord, the financial year 22-23. What they have done, assessment order has been passed. Supreme Court has made an interim management that the proceedings may go on. Assessment order may be passed, but no final effect should be given to the assessment order. And usually that is the order generally passed nowadays. So, my lord, what they have done, once assessment order has been passed, though the assessment order has not been given effect, the material collected during the assessment, that material now forms the basis of this 201(1)(a) and 271(c) proceeding.
So according to you, in view of that protective order, these materials could not have been also used?
This is one such, that is that point we have taken. But most importantly, my lord, I am on a key question would be whether I am the person responsible or not. Secondly, my lord, whether, my lord, this amendment can be pressed into service for the relevant period.
Where that part has been
Yes, my lord.
considered? It
Kindly come to page 680.
680.
680.
Yes.
Kindly take, my lord. This is we are reading 680 onwards, my lord.
680.
Oh, exactly.
Yes.
194B and on section 194B
and 204.
204. The company has argued that there is no privity between the so and so. The definition of person responsible under section 204 is broad and inclusive. It covers, in case of company principal officer, any person who is responsible for paying any income is chargeable under the act. The assessee being a principal distributor is a central link. Now, my lord, I took this point, the amendment point, where have we taken? Just 1 minute. Amendment point, where have we taken? No, it has been taken. Kindly take, my lord. Kindly take, my lord, my objection at page 673. No, it has been recorded.
Yes.
Kindly take, my lord. The amendment point. No, I can't read. Tell me amendment point we have taken. Just show that. Just 1 minute, my lord. Just one. Yes. Well, on the threshold of 10,000 under section 194B. That is the point taken is at page 670. 67. Kindly
Yes.
take, my lord, page 670 for once.
Yes.
This is what we took this point. Kindly take preliminary objection along with jurisdictional fact, non-applicability of section 194B of the Act. We have taken this point.
Where is that?
My lord, 670.
670.
Last.
Yes, preliminary objection with the yes, non-applicable 194.
Yes. As per section 194B, as it stood during the financial year 22-23, the said provision is clearly not applicable to the present. Section 194B requires reduction from extract from the said section is so and so as it stood for the year in consideration. So, my lord, then at that point of time, it was the case when the single transaction exceeded 10,000, not the.
But not in so many words. This objection was.
Yes, it has been taken. It has been
Where
taken.
is that?
My
That
lord,
amendment came into force after.
My lord, the amendment. My lord, we have referred to the earlier amendment, the earlier provision. Kindly take, my lord. Kindly take 194B, when the person responsible, relevant period, 194B, the person responsible for paying any sum, any income by way of winnings from any lottery or crossword puzzle or card game or any other game of any sort, in an amount exceeding 10,000 rupees, shall at the time of payment thereof deduct income tax thereon at the rates in force. But this is the provision of law as it stood prior to 1/4/2023. 1/4/2023 introduces the concept of aggregate of the amounts received during a financial year. If the aggregate of amounts exceed 10,000, then my lord, obviously, my lord, whoever is person responsible for paying would be required to deduct tax at source. My 659, if your lordship can take, there are several objections filed. 659. 659. It starts at page 659. Where are you reading?
657, 659. 659.
My lord, kindly take, my lord. Six five nine, 657 now. Kindly take 659.
Yes.
Where are you restricted? My lord, kindly take G. Wait.
Yes.
G at 68661. While not being applicable to the company in any event and without prejudice, it is stated prior to the amendment to section 194B, effective 1/4/2023, there was in fact no TDS on the aggregated. So clearly taken by and not, my lord, dealt with in that fashion.
Mr. Mojumdar, maybe you have taken that in the objection, not pressed at the time of
We have
hearing.
pressed everything, man. We have pressed it. We have pressed because, my lord, you are
To
not
appear from the order,
Well,
what
your-
was pressed, Mr. Mojumdar, there
Yes.
may be many points taken in the objections, petitions,
This is a
etc.
jurisdictional issue. Two jurisdictional issue. One
Yes.
is, my lord, the person, that's one. Just one is, my lord, the person responsible for paying, and that's the key issue in this matter. Second is, my lord, for the financial year 20 to 23, an amendment brought.
With effect from 1/4/2023 can be applied.
Cannot be applied. Because this is TDS. This is not assessment. TDS would obviously relate to the financial year.
Has to be because the payments made during
Payments made,
that
my lord, then, my lord,
that
the certificates are
financial
issued
year.
and exact.
So with
Quarterly-
regard to the
quarterly
payments
returns are
made
filed.
for an earlier financial year, whether the subsequent
Absolutely.
provisions can be given
Can-
effect.
This is second point. The first point is, my lord, we are not the person responsible for paying, even as per the relevant rules of the
So the
state government.
proceedings are continuing. What is the prayer, what is the interim relief?
Mala, interim relief, what we have sought for, kindly take the prayers at page 91. This is volume 1, I believe.
Yes.
Kindly take, Mala, the interim relief, injunction restraining from taking any step or further step.
Which prayer?
Prayer F.
F.
F and G. G would be ad interim, my lord.
Restraining the respondents from taking any steps. Furtherance of the impugned order or communication. Relating to. This is the communication which you have placed at page
Yes.
6.
These are the
That is the communication.
Yes. This is, my lord, the order disposing of objections.
So no final.
No. My lord, the final decision, my lord.
No, you are saying that let the proceedings continue, but no final effect.
Order should be given. No final order should be passed. But I am not here to stall the proceedings entirely.
Yes, because
My lord, that may create, my lord, the equities may be required to be adjusted. Let the proceedings.
But the other way around, Mr. Mojumdar, would be
Yes.
that would be in effect delay.
Yes.
But if the entire thing is done, I give you liberty to challenge everything.
Well, I cannot, because then it becomes an appealable order.
Yes.
But, my lord,
All Mr. Mojumdar, all points also can be raised in
but
the
my lord, jurisdictional issue, my lord, I place before your lordship.
Yes. I'm not saying that you are not entitled to raise.
Well, only
But
one judgment.
these are the issues, Mr. Mojumdar. There are some issues.
Malab,
which
we are
relate
not,
to
adjudication,
facts are
but
considered.
adjudication is yet to be made. We are at that stage. The order only has been passed disposing of my preliminary objection.
I appreciate.
Yes.
Mr. Mojumdar, I'm not suggesting that this writ petition is not maintainable.
Right.
Not now the considering, Mr. Mojumdar, there are very many objections which is taken at the preliminary stage.
Yes.
Now, this is one of such objections. Yes, one you can say is with regard to the effect of subsequent provision or retrospective effect to a provision being given.
But that is one.
That
But
is
main,
one.
main argument
But
is
with regard to the responsibility, whether
yes.
that facts also to some extent
Malad, the
that we
facts
consider.
are undisputed because Malad, the order records, I am not distributing money directly. I am a central link. That is all. That's the finding of fact by the authority. The order does not say that I am directly actually disbursing the amount.
Show me that.
Yes, only that
once.
part, nothing more. Kindly come to that part. Kindly come to page 681. So this is a finding of fact arrived at by the
681.
681. Part of the order, Malad.
Yes.
Part of the order. First paragraph itself. The assessee being, my lord has got, I'm sorry, my lord.
Being the, yes, the principal distributor of lottery.
And the central link in the price distribution chain clearly falls within this definition. How am I, how can this, this is the only finding. Then my lord, in a
So according to you, you may be a central link, but you
I
are
may
not,
yes,
but you are not actually
I am not actually disbursing.
disbursing.
Either the state disburses, I am allowed to disburse prize money up to 10,000. That is all through my distribution network. It's not that I am disbursing. Retailers are disbursing the amount. But in my objection, I made it very clear expressly that I am not disbursing the amount. The retailers are disbursing the amount. Those issues have not been considered.
Show me the notice which was issued.
Notice your lordship
the
will
basis
find.
of which this proceeding was initiated.
Yes. My lord, only one thing before I take your lordship to the notice. I'm sorry, my lord.
Yes.
Kindly come back to the order.
681.
680. 681 I read.
Yes.
Kindly take 680.
Yes.
The second paragraph at 680. The Honorable Supreme Court in so and so, that is Eli Lilly, held that the obligation to deduct TDS is upon the person who actually disburses income. And my lord, this order is a kind of oxymoron. It's a self-contradictory order. That at one stage it says that he actually who is person responsible has to deduct TDS, and he says then I am to be fastened with the liability since I am the central link. Well, these two paragraphs are self-contradictory.
But next paragraph, Mr. Mujumdar.
Yes, I'm coming to that, definitely.
Once the assessee distributor disburses winnings.
Once the assessee distributor disburses winning, my lord, I am not directly disbursing winnings, my lord, that is indicated in
But
my...
the authority was of
My
the
lord,
view
let us
that you are
take-
directly
let us
disbursing.
Let us take the worst case scenario. The law requires me or through my network to disburse winnings up to 10,000. There is no doubt about it, my lord. I have placed the rules. Even the rules were placed before the authorities. But my lord, the law does not require me or does not permit me to disburse winnings in excess of 10,000, cumulative or otherwise. If it is a cumulative disbursement, my lord, suppose 5.
So in any case, according to you, even if you are distributing,
yes,
you cannot be held responsible for
yes, that is
deduction of tax.
yes. Because my lord, we are dealing with, your lordship has dealt with these matters for last 3 years. And we know, my lord, your lordship has that other revenue background also. So my lord, today, my lord, we are talking about fiscal statute. My lord, nothing can be read into a fiscal statute. My lord, I have placed
Where
the
is Mr. Singhania?
My lord, I don't know, my lord. The lordship wanted to look at the show cause notice.
Yes.
So it's my duty to point out the show cause notice. Kindly take the show cause notice. One is at page 628, volume
28,
and another is at page 630. One for my lord 201A and another for 271 capital C.
For two separate notices.
Yes. Same order.
6 to 8.
6 to 8.
Oh, sorry. See this volume first.
I'm sorry, my lord. It should be volume 3. It
Yes,
should be
yes.
volume 3.
TDS has not been deducted before disbursing and no corresponding TDS return was filed.
Right.
So these are the issues.
This is the issue.
And
now
what is the other one?
kindly take 630.
630.
Identical notice, my lord. That
This
a-
is
this
for
is
271C.
Capital, penalty. Yes, yes. Very good.
Petitioner who claims to be a Mr. Mujumdar, where have you stated that the nature of the business which you are carrying?
My lord, kindly take, my lord, paragraph. Third paragraph, kindly take, my lord.
Paragraph 3.
I'm just 1 minute, kindly take, my lord. I will give the entire thing.
So is the distributor for the sale of lottery?
Yes, sale of lottery.
The
Appointed by different organizing states.
petitioner claims to be the distributor for sale of lottery tickets of such lottery schemes as are allotted to the petitioner by the respective state governments through its network of sub-distributors, area distributors, stockists and sub-stockists. Full stop. The petitioner claims that it's a company,
It's a number.
that the that the petitioner company is not disbursing the prize money to the winners of the lotteries. What is Mr. Singhania, none of you are not appearing alone. Someone has to. Maybe I'm not saying that. Yes, maybe if someone has to appear. He has served the copy and I was about to pass an order.
I think the copy has been served on the department directly.
Maybe
But
it's your client who is responsible for that.
I will have to take instructions.
Yes, one thing, you may take instructions. I'm telling you because the order, show cause notice was issued. And they raised a preliminary objection with regard to the jurisdiction. That has been turned down. Now the proceedings are continuing. Now they have raised various legal and factual issues. Not the factual because facts
It's all
according to
legal.
Mr.
No.
Mujumdar is admitted.
No.
It's only the legal issues as to whether such a notice or such a proceedings against him could have been continued. So now it has been decided against the petitioners. So I'm not stalling the proceedings. Let the proceedings continue, but no final order to be passed without the leave of the court.
That is all I'm saying. In this type of cases is always one Mr. Mujumdar asserts and one Mr. Mujumdar denies. And I am a very big fan of the other Mr. Mujumdar. I am a greater fan.
কি হলো? কি বলছিল? To the winners of the lottery, but it's actually the retailers who are actually distributing the prize money
Below 10,000, my lord. Below 10,000.
below 10,000, below rupees 10,000. A show cause notice, show cause notice under section 201 within bracket 1/201 within bracket 1A of the Income Tax Act 1961, alleging that the petitioner has not deducted TDS before disbursing the prize money and no corresponding TDS return was filed for the relevant quarters pertaining to the financial year 2022-23. A consequential notice under section 271C.
Two 271C.
Consequential
No,
notice.
it's not separate.
It's a consequential.
Yes.
It's consequential to
No,
cash
sir,
payment.
basically,
But
but
it is not
consequence,
consequential.
well, it is 271C is failure to deduct tax at
Yes.
source penalty. That's it.
All right, consequential corner credit.
Because consequential may create some.
All right. A further notice under section 271 capital C of the Income Tax Act.
Same date, my lord, same date.
No,
different date, different.
21st July.
21st of July. ও আগেরটা না
18 July and
20 যেটা
21st.
হয়েছে সেটা ডেটটা লিখুন জুলাই
18,
18 2025 ঠিক আছে প্রথমেরটা সেকেন্ডটা হচ্ছে শোকজ দি নোটিস আন্ডার সেকশন 271 ক্যাপিটাল সি অফ দি ইনকাম ট্যাক্স অ্যাক্ট ডেটেড July 21 2025 was issued alleging that was issued asking the petitioner to show cause as to why penalty under section 271C should not be levied upon the petitioner for failure to deduct TDS before disbursing the prize money and for non-filing of TDS returns for the relevant quarters of the financial year 2022-23. Full stop. Mr. Mojumdar, Lanet senior advocate appearing for the petitioner submits that the petitioner filed several objections before the concerned assessing officer raising objections as to the initiation,
Assumption of jurisdiction.
Raising objection as to the assumption of jurisdiction by the concerned assessing officer. Full stop. He further contains that the petitioner cannot be said to be a person responsible or responsible.
Yes, person responsible for
cannot
paying.
be said to be double inverted comma মধ্যে a person responsible to deduct tax
For paying. Exact expression is person responsible for paying, section 204.
a person responsible acha cannot be said to be a বলে inverted comma the person responsible for paying inverted comma closed as used in paying শুধু paying ঠিক আছে inverted comma closed used in section 204 of the Income Tax Act 1961. First step. Mr. Mojumdar further contains that the assessing officer rejected Mr. Mojumdar further contains that the assessing officer gave a retrospective effect to the amended provision of section 204
194B.
194 capital B of the 1961 Act, which came into force on and from 1st April 2023 for the financial year 2022-2023.
Right.
First up, he therefore submits that the assessing officer exceeded its jurisdiction by assuming jurisdiction in the case on hand. Full stop. Paragraph. The learned Deputy Solicitor General of India, assisted by Mr. Singhania, appears for the Income Tax Authority. First up, the learned Deputy Solicitor General of India submits that that he has only received the papers, that he has received a voluminous copy of the writ petition only yesterday. And no, you have received or you have not yet received.
I have received the information of a voluminous copy, please.
Oh. The Deputy Solicitor General of India submits that he is yet to receive a copy of the writ petition from the concerned department.
We can give a copy.
I will write from the concerned department, and some time is necessary to consider the issues raised in the writ petition, which, according to him, is a voluminous one. Full stop. Paragraph. After going through the submissions made by Mr. Mujumdar, it appears that several legal issues going to the root of the jurisdiction has been raised by the petitioner in this writ petition. For such reason, this court is inclined to entertain this writ petition. Full stop. Let affidavit, yes, Mr. Majumdar, you have to file affidavit. Let affidavit in opposition. The learned advocate on record of the petitioner is directed to serve a copy of the writ petition upon Mr. Singhania, learned advocate representing the income tax authority by
Today.
in course of this day. First up, let affidavit in opposition be filed within a period of 4 weeks from date, semicolon, reply thereto, comma, if any,
2 weeks, madam.
comma, be filed within 2 weeks thereafter. Full stop. No useful purpose will be served in stalling the proceedings, but no final order.
Orders, my lord, both cases.
But no final orders without the leave, or
Without
if
the-
no final orders
We pass without the leave.
on the notices issued as mentioned supra,
Yes.
to be passed without obtaining leave of this court. First up, parties will be at
But
liberty.
I think মানে 6 weeks and 2 weeks vacation এর মধ্যে পড়ে আছে আমার। 4 weeks and 2 weeks কি হবে? মানে then
Today we are on
6 weeks and 2 weeks, man.
No, vacation, it will not be within vacation because 4 weeks ends on 24th of November and 2 weeks will end on 8th of December.
No problem. No problem. Then it is.
Will be at liberty to mention the matter
Mention the-
for enlistment under the heading hearing after expiry of the period fixed for exchange of affidavits.
Grateful. Deeply obliged. Take your lordships kindly.
Flight timing gone
No, madam. Flight, but today I am traveling to Delhi, madam.
today.
Evening flight to Delhi. Tomorrow I will go back. Oh, Joseph, উঠছে না।
Every service. Yes. Where is the other matter? Trust me. Yes, Mr. Mujumdar, please take back.
May I take your lordships kindly? madam?
Yes, yes. Also the book.
This is not her.
Oh,
Yes.
Lordship, this is the matter, my lord, where the petitioner wife has been brutally beaten by
Yes,
the
where is the-
husband.
The item number,
Advocate for, yes. What happened?
item number 25.
This one, even in today's this one, I mentioned it, she was very much present in the court.
What happened? What happened?
The honorable judge allowed my prayer and ultimately it was upgraded, but it did not reach.
Upgraded.
It was upgraded, but
Yes.
did not reach till date.
Then
And
I'm,
today there is no possibility. Even today, tomorrow, not possible. I think. No, not even a single anticipatory paid application. has been-
I'm keeping it on 6th.
6th means Thursday, Lord.
Yes. The learned advocate appearing for the item number 4.
4, Lord.
The learned advocate appearing for the
My lord, may I interrupt for a moment, my lord? I have gone through the prayers. I have gone through her prayers. Even all the prayers are allowed. I have no objection. Even her prayers are allowed. I also want a fair investigation. Even if all the prayers are allowed, the charge sheet is a natural conclusion of an investigation, my lord. If all these prayers are
no,
allowed,
she wants arrest.
My
That
lord,
is
so that is, my lord, arrest is
my
the
lord,
discretion of the
my
investigating
lord,
agency.
that I cannot pray in the lead
Direction, yes.
jurisdiction, Lord.
So I'm directing the
What I am praying for a, my lord, the fair investigation by a independent, my lord, the officer of
wants-
the inspector rank, lordship.
That can be done. Whoever, even the SP is interested, I have no objection, madam.
My lord,
Yes,
arrest I
who
cannot
is-
say, Lord.
yes, that is. Yes, Mr. Shah, what do you say? Who is appealing for the state?
My lord, there is-
Yes, where is Miss Bose?
By-
No, fair investigation I also want because I had given some documents that day, my lord. I was in Prime Minister's duty on that very day. On 27th, I came to Alipurduar. I was under SP's control and Prime Minister's duty, my lord. And I returned on 29th.
My lord, my
The date
prayer,
of incident is
since he
28th.
has-
What is your allegation against the present investigating officer?
my lord,
Anything?
investigation is not, my lordship, kindly see.
Even if the IO is
FIR
changed, my
has
lord,
been
I have no
registered
objection.
long back.
Whoever is the IO, I have no objection.
My lord,
I will fight
Yes,
the
madam.
case on merit.
Yes.
Lordship, first of all, I would, on the last occasion, I already submitted report, Lordship. I audit everything, only the principal, of course, was not arrested.
that is my
No, that is
concern.
the other thing. Now the petitioner wants a fair investigation by
Fair
an investigation
going on.
officer of the rank of an inspector.
Yes, your lordship, what is the objection
So
of the
private
state?
respondent is also admitting to that.
If Lordship
So
can be,
tell me who can be the investigating officer of
Concert
the
IC may take.
Concert,
The concert IC of the PS may
Yes.
take up.
IC?
I see, yes, Lordship.
But the IC may be having other duties.
There
That's
is only one inspector.
OC is there, Lordship, but he is not the inspector, he is sub-inspector rank, but he can be.
Who is the
No.
sub-inspector rank? Who is in the sub?
OC, officer in charge, Lordship.
Lordship,
But only
the
senior
same-
He
sub-inspector
says
can do,
inspector.
my lord, the same thing will happen. Lordship.
The
My lord, since
inspector-
they are also praying for a fair investigation.
Lordship,
No, that's, he's also,
Lordship, any inspector from DIB also engage, Lordship.
Done.
That can be done. Because they have not that much pressure, Lordship, in DIB department.
DIB department.
DDI can be given. Now there is one in the district, DDI. One inspector in the DIB. Or it can be given to the SP, SP's discretion, any officer SP, any inspector SP can. choose.
That will be decided by the superior, that will be better.
I think I am directing the SP is the party, is the
Yes,
party.
yes, yes.
Yes, he is the part.
SP is the part. Respondent 2, Lord.
The
That my prayer is also fair investigation.
the petitioner alleges inaction on the part of the police authorities. First up, petitioner is the wife of the respondent number 4. First up, she lodged a complaint against the fourth respondent on June 11, 2025. And it has been alleged that the police authorities have not taken any steps apart from registration of an FIR, have not taken any effective steps apart from registering an FIR. First up. On the last occasion, that is on October 29, 2025, the learned advocate representing the fourth respondent submitted that an application for anticipatory bail has been filed by the fourth respondent, which is pending before this court, and the same may be expected to be taken up very soon. First up, when this matter is taken up today, the learned advocate appearing for the fourth respondent submits that he has mentioned the matter before the concerned bench, and the application has been upgraded, but the business of the court did not permit the application to be heard today. First up, he also submits that he submits that the fourth respondent do not have any objection in in a fair investigation being conducted on the complaint made by the petitioner. First up, he submits that the fourth respondent has materials in support of his contention that he was not present at the relevant point of time, and he was on a duty assigned on account of visit of the Prime Minister, of the visit of the Honorable Prime Minister of India. Just a paragraph. The learned advocate appearing for the state submitted a report dated October 26, 2025, wherefrom it appears that the police authorities conducted multiple raids to apprehend the FIR named accused, including the fourth respondent, and the other FIR named accused, excepting the private respondent, have obtained anticipatory bail from the competent court. First up, the application for anticipatory bail. Paragraph. Heard the learned advocates for the respective parties and peruse the materials placed. First up, the application for anticipatory bail filed by the fourth respondent is pending before this court. First up, be that as it may, both the parties want a fair investigation to be done by a competent investigating officer. First up, the learned advocate appearing for the petitioner.
That sheet, there cannot be any direction now.
Charge sheet has been submitted.
My lord, I have no instruction.
My
that
lord,
that has been
what is the
submitted.
procedure
It
now?
was it was arrested only. When the charge sheet was filed, have you disclosed in the
Report.
No, charge sheet. No, charge sheet of the first 490. First 490.
My lord, that.
what in respect of this? The petitioner wants an impartial investigation to be conducted by an officer of the rank of an inspector. First up, the learned advocate appearing for the private respondent also do not have any objection to such prayer. First up, in view thereof, the concerned superintendent of police, Kuch Bihar district, is directed to depute a competent investigating officer of the rank of an inspector for the part and direct the present investigating officer to transfer all records pertaining to the investigation in question to the investigating officer to be appointed by the superintendent of police pursuant to this order. First up, with the above observations and directions, the it is expected that the investigating officer appointed by the investigating officer to be appointed by the superintendent of police shall conclude the investigation in accordance with law. Partial has to be using those words means because the person is not yet appointed and you are saying that in an imperishable law, in accordance with law, as expeditiously as possible with the aforesaid observations and direction, WPA number such and such stands.
I'm extremely grateful.
What do we say?
হ্যাঁ হ্যাঁ হোক না যেটা সত্য সেটা হোক
Same melody has single PPO. Interest in calculation.
Primary teacher.
Yes.
What is the delay? How much is the delay?
Delay melody. PPO issue in melody 31st March 2024 and melody retirement date is 31st March 2024. PPO was issued in melody 11th June 2025.
More than a year.
Yes.
Yes. Disposed of. Next.
75, I'm for the petitioner, Lordship.
$76 I'm for the petitioner. Here my petitioner is the widow, husband died, dying hand.
Yes. Already disposed of. Next.
76
I'm for the state.
You're for the state.
75 is the matter relating to overturn.
76.
77. 77.
76.
76.
What is 77 has been called off.
Yes.
Oh, yes. Yes. What trial? So you want refund of that overdraw amount with interest.
Lordship, sir.
All right. Disposed of. এখানে record করে দিন state is represented by Mr. Pal. Yes, next.
My lord,
78.
my lord, sorry to interrupt in between. In item
Yes.
number 74, my lord, for state, I am also there, my lord, but the
Item number?
my 74, my lord, for state, I was there, my lord.
74, Mr. Shantanu, Kumar Shantanu.
Yes, ma'am.
ঠিক আছে?
দেখতে হবে।
Yes.
Yes. 78. Is it for overturn?
Lordship, this is also over trial.
Yes, Lordship. I represent state.
Teacher of a primary school.
Yes.
Yes, next. Disposed of next.
Grateful, Lordship.
79. Lordship.
Mr. Boss, item number 70 is mine.
Oh, that in that. Correct. 79.
79 is
Over.
over trial. 79 disposed of. Yes, call the next matter. 80.
Over.
I am for the
Overdraft.
statement. I am for the statement.
Yes.
I am for this.
Trial. Yes. State is represented. Yes, next.
81 minutes I pay for the state.
You are for the state. What is this? Over trial.
Overturn.
Over trial. Yes, disposed of. Please give your appearances mentioning the item numbers. Yes, next.
Yes, sir, on the state.
82 million single people interest on gratuity and overdraft.
Single PPO.
petitioner is a librarian of a library.
Yes. Disposed of. Yes, next.
83 minutes I appear for the state.
83 मतलब single PPO.
83, single PPO. Yes, disposed of. Next.
Oh, 84 device. Device PPO.
Revised PPO.
আমি আছি।
Interest will be calculated from which date?
From 14 February 2020.
14th February.
Yes. Device PPO.
Yes.
Grateful option.
Yes, next.
85.
85.
Single.
85. Single PPO.
Yes. Primary teacher.
Yes. Disposed of. Next.
Right, yeah, 81, 84 to this, it should be, so 81. I'm for the SLS.
Single people here petitioner is the owner, so died.
Died in harness.
Yes.
It should be from the date following the death.
Following the date of death, or date of accept.
Yes, it should not be from the date of death. It should be from the date following the date of death.
Following the next date of the data.
Yes.
Exactly.
Date of death of the petitioner's husband.
Husband, yes.
You have not corrected that. Petitioner's wife till the date of such claim. Yes, disposed of.
Yes.
Good, good.
Lordship, I am led by Mr. Shah for the petitioner.
Yeah, I'm for the petitioner, Lordship.
Lordship,
What
one
is the
small
matter
indulgence,
related?
Lordship. In item number 76,
I'm
I
for the
forgot to
state.
give my name.
76 you are
Lordship.
appearing.
Yes.
25 years. Who is
I'm for
appearing?
the state.
Grateful,
What is
Lordship.
the matter relating to a issue of transfer of the petitioner? Lordship, he is a school teacher, secondary school teacher, high secondary school teacher. Lordship, this is the second round of litigation. Lordship, the petitioner had in the case. I'm giving the little backdrop of the case first. Lordship, the case was like the petitioner was a regular teacher who was appointed in the year 2014. After expiry of Lordship more than 11 years, Lordship Lordship, after being eligible for transfer, Lordship in the year 2020, he have applied for transfer before the authority concerned, Lordship, in the year 2020, and that application was that application was made through a post. Subsequently, when the Uchasri portal came into being, in the petitioner had also applied through USOC portal as well. Now the USOC portal, after transaction of that application, by an order dated 28th of August 2021, the authority concerned has rejected the prayer for application for transfer which has been uploaded in the USOC portal. Which order was ultimately challenged before this honorable High Court, and by an order dated 20th of August 2025, which is paid at page 57 of my application, that order has been set aside, being illegal. Now, Lordship and the learned and the honorable court has directed the authority, the DI, that also given a liberty to the petitioner to file a application afresh for requesting the petitioner for renewal of his prayer for transfer. Accordingly, Lordship, I pursuant to the said order, Lordship, I had immediately on 25th of August 2025, I applied for transfer again. Lordship, that application was transacted, and ultimately by the impugned order dated impugned communication dated 23rd of September 2025, the DI has communicated to the commissioner that there is no available teachers being found in proposed replacement of the petitioner. That's why the prayer for transfer of the petitioner cannot be acted upon or cannot be accorded. This was the sum and substance of the case against which I have come before your lordship. Now, let's kindly see the page 57 of my application, where the learned this honorable court has passed the order whereby the earlier order of rejection of her transfer was set aside, and direction was given upon the respondent to act upon the to consider the prayer for. Let's kindly see.
My lord, I am for the commission.
Yes.
Hey. My lord, if your lordships kindly turns to page 58. My lord, my submission has been recorded that, my lord, there is a notification with regards to transfer of single teacher. My lord, that is, my lord, 3rd January 2022. That notification provides for, my lord, if there is a single teacher makes an application for transfer, the school authority shall not reject the application. Rather, my lord, the school authority shall forward the application to the DI. And DI shall make an endeavor to find out an alternative arrangement. And if such arrangement is made, my lord, petitioner, so that the transfer aspiring candidate may be transferred to his preferred post. Oh, my lord, transferred place. My lord, now, my lord, in that writ petition, my lord, honorable coordinate bench directed liberty was granted to the petitioner to make an application afresh. Pursuant to that order, my lord, petitioner makes an application, and, my lord, school authority was already forwarded his application to the district inspector of school. Now, my lord, kindly turns to page, my lord, 63.
The impugned
That
order.
is the communication impugned in this writ petition.
Yes.
23rd of September 2025. This communication, my lord, was made by the district inspector of school to the secretary, Central School Service Commission, stating that as there is no alternative proposal, this office is unable to forward the application of the petitioner for granting transfer on special ground. So, my lord, DI has acted in terms of the 3rd January 2022. My lord, being an officer of the court, it is my duty to point out before your lordships. Now, this position has been well settled by the division bench of the Honorable High Court, presided over by Honorable Justice Sabubroto Chakraborty, that the notification dated 3rd January 2022, my lord, gives an opportunity to the DI to find out an alternative arrangement in a time-bound manner. So it is the duty of the district inspector of school to find out the alternative arrangement, any who can cook. It is not the duty of the district inspector of school to place the transfer application kept in abeyance for a time being, my lord, for the time being. So, my lord, similar, my lord, relying the division bench judgment, if your lordships kindly adjourn the matter, I shall provide the copy of the judgment. So, relying that judgment.
What did the division bench say?
Division bench, my lord, fix a time frame order, my lord. Division bench, my lord, directed the district inspector of school to find out alternative arrangement within 6 weeks.
What is
And
the
then
alternative
forward.
arrangement which can be
My
made?
lord, my lord, alternative arrangement, the concept of single teacher is that, my lord, in a school, there must be 2 or 3 English teacher. If in a school, there is only one English teacher, then if that teacher is transferred to another school, then the worst sufferer would be the students of the schools.
Yes.
So therefore, alternative arrangement from nearer school, who can man the post of the petitioner if he is transferred.
So these are all the factual aspects. How can it be decided? Because whether in the nearby schools, there is also available teachers who can be transferred to the school and so as to enable the petitioner. These are also
My lord,
disputed questions. So how can it be
disputed.
decided?
My lord, on the basis of DI, my lord.
It is, my lord, the duty of the DI to stopgap measure. My lord, the nearby school teacher, the teacher from a nearby school can take the classes of the schools.
Mr. Roy,
Till-
kindly.
Yes. Yes.
Mr. Roy, kindly allow me. My lord, I am for the DI, my lord.
Yes.
I would ask, I am been led by Mr. Saha, London
Yes.
AGP. The instruction which has been provided, we have given every endeavor, all the nearer school, we have asked for the teacher who are teaching education, and all the school have a single teacher. Now
Yes.
placing, that is the difficulty which the DIE has faced. If my lord goes through the report, my lord will
That's the
find that the
scenario. That's
teachers.
the present scenario. In most
Yes.
of the schools, in a subject, there is only single teacher. So how can an alternative arrangement be made?
Grateful.
It's difficult. So let affidavits be filed. Cannot be
Lordship,
decided.
no. Lordship, may I say? Lordship, this particular scenario was addressed upon by the Honorable Division Bench in a particular judgment. Lordship, I am just handing over the judgment. That is Shama Prasad Roy versus State of West Bengal. Lordship, kindly see at page 6 onward, 4, 6 and 7. Lordship, this particular problem was raised before the Honorable Division Bench. The Division Bench categorically hold that kindly see page para 4. The para 4 of the judgment speaks that the appellant appears to be that the purpose of transfer is defeated and the respondent authority cannot on pretext of non-availability of the willing teacher indefinitely keep the said application pending. My application is not pending, but the thing is that my application has been turned down only because of non-availability of the willing teacher. In a practical scenario, no incumbent of my fraternity can conquer my prayer for transfer because it is not a mutual transfer scheme. Inevitably, I believe that in a practical scenario, no incumbent can conquer my prayer. Now, the paragraph 6, the Honorable Division Bench hold that there is nothing on record to show endeavor was made for the last 4 years in finding out the willing teacher to join the said school on a temporary basis for filling up the resultant vacancy. There cannot be any doubt that the welfare of interest of student are paramount consideration. Now, however, an
Factor
application
different, my lord. Factor different. Here.
Let me finish. An application for transfer cannot be kept in abeyance unreasonably for an indefinite period of time. The respondent are not contending that the petitioner is not eligible for transfer. Now, the penultimate direction at paragraph 7. In these circumstances, we give the respondent 6 months time to find out the teacher to fill up the resultant vacancy which is created after transfer of the appellant. The appellant within the aforesaid time as soon as after expiry of 6 months period should be transferred in accordance with law. This is the judgment that is holding the field right now.
Sir,
Pursuant to the
I
judgment-
appreciate your anxiety, but the situation is so. How can this vacancy, which is to be created after your transfer, be filled up? How?
If my employer is absolutely silent with regard or is silent or inactive in regard to the filling up of
Only
the
so
post
let
and all,
affidavits be
it cannot.
filed.
Affidavit, there is no disputed question of law. This is a pure question of law. There is
No,
no
not a
scope.
question. Not a pure question of law.
May I say?
Cannot
May I
be
say
a pure question of law.
another judgment, Lordship, relying upon the particular judgment, Lordship, hand over. I am relying upon Mohammad Nadim Akhtar Danish, the coordinate bench of this Honorable High Court, relying upon that particular Samaposa's judgment, has directed the similar direction at page 6 onward. Kindly see para 6. In the similar circumstances. Para 6 onward.
But the facts are different because in those cases,
Are
endeavor was not made.
no,
Endeavor was not made. But here the endeavor has been made.
no,
You cannot say
filling up,
that endeavor has not been made.
no
DI
endeavor for filling up the vacancy. Judgment speaks about this.
Mr. Saha,
Sorry,
our report says,
let
our
the
report says, our report says that the endeavor has been made, the notices were issued to the teachers, but DO's school, the nearby schools, we can take teachers from the
your
nearby
endeavor
schools.
relating to concurrence of other incumbent. I am not on that. I am only that the endeavor to fill up the vacancy. I am not that. Unless my vacancy would be fill up, my prayer for consideration.
What is the ground on which you have sought for transfer?
See, my ground, I am a eligible incumbent for transfer because I have completed
distance ground.
Distance ground, 430 kilometers ground. See, I have a 2 years old baby. I have lost my parents. I have nobody to take care of my baby and my other family members of that is wife. I am residing currently at Alipurduar. I am hailing from district from Malda. Lordship, I'm in a precarious condition. Lordship, I'm asking for transfer. Lordship, this is the second round of litigation. Kindly appreciate this thing. If
Sir,
my
only one thing.
Lordship.
So a decision is to be taken. Let them file their affidavits. Unless they disclose their stands, it cannot
Lordship,
be
what in respect
decided.
of what affidavit? Lordship, I really fail to understand. Lordship, what affidavit is required? Lordship,
The learned advocate appearing for the petitioner submits.
Lordship, that will be a very Lordship. That would be prejudicial.
My lord, may I suggest,
I'm beseeching your
may I
Lordship.
suggest one thing?
Yes.
Mr. Saha, just a minute. My lord, may I suggest one thing? Let a direction be given upon the DI because the time frame on the last occasion was only 3 weeks. So if the time frame is given for some more time, then let the DI to search for more more opportunity or options.
Yes, it may be. It may be.
The learned advocate appearing for the petitioner submits that the prayer for transfer was not considered favorably by the concerned district inspector of schools within bracket AC Alipurduar on the ground that the
non-availability of the teacher. Impugned order dated
on the ground that
63.
the school teachers have shown their inability to provide any suitable substitute in favor of the petitioner. Full stop. The learned advocate appearing for the state submits that some more time may be given to the district inspector of schools to find out an alternative arrangement to find out as to whether there are willing teachers to cater to the resulting vacancy that may be created upon transfer of the petitioner. Full stop. Heard Mr. Roy, learned advocate for the School Service Commission. Full stop. Paragraph. Yes, how much time?
My lord, minimum 2 to 3 months.
Let affidavit in let a report in the form of an affidavit be filed by the district inspector of schools within a period of 8 weeks from date, disclosing therein the steps taken by the district inspector of schools to find out an alternative arrangement to cater to the resulting vacancy that may be created due to the transfer of the petitioner. To stop, list this matter after 8 weeks.
Grateful.
Diplomat.
Yes. Next.
Lordship, I am for the petitioner. Lordship, the service upon all the respondents is not complete.
On all the respondents is not complete. What is this issue?
Lordship, illegal
What have you
construction.
prayed for?
illegal construction of community hall.
Who has made illegal construction? Mr. Paul, you are appearing for?
Lordship, the anchoring party is respondent number 5. Pradhan.
Pradhan. You have not served upon the Pradhan.
Lordship, delivery needs, it will take some time.
The learned advocate appearing for the petitioner submits that all the respondents have not, that service of a copy of this writ petition has not been effected upon all the respondents. To stop, list this matter before the next available circuit bench. Full stop, petitioner is directed to effect service upon the unserved respondents in the meantime and file an affidavit of service on the next day. Yes, next.
State is represented.
State is represented.
Lordship, I am the petitioner in person.
Well, I am for the state.
27.
27.
Yes.
So I have prepared this petition due to unauthorized use of my land, my lord. The state is carrying out a project under Pradhan Mantri Gramin Sadak Yojana. And for this project, stand required land, additional land required, but state hasn't issued any notice to me, and without taking any prior consent, it has carried out construction works on my land. And being aggrieved, I have approached the landed district magistrate and filed a written complaint dated 3rd April 25, but it was not considered.
Page 18, madam. The difficulty is that he did not make a party to the district magistrate.
You are representing whom?
Or to the state, district magistrate also, but not make a party.
Actually, state panchayat and rural development department is concerned with this project actually. There is also union involvement of the union in this case as well.
Yes, have you utilized the property of the petitioners?
Well, I have to take instruction. Well, let him make a party to the district magistrate. I will file a report from the district magistrate.
My lord, can you see annexure?
Yes, annexure.
Annexure P3 at page 38. I made a representation to the learned chief secretary to the government of West Bengal.
What will the chief secretary do?
Because the chief secretary is the head of the state level select committee, which is under the guidelines of the Pradhan Mantri Gramin Sadak Yojana.
Maybe.
Yes, madam. Under guideline 10 5%, I have filed the relevant extracts, madam. Kindly see page 15, my lord. 15 guidelines 7.3. It states that state level select committee would scrutinize the proposals to see that they are in accordance with the guidelines, and that the proposals after scrutinizing it gives clearance to the project.
What is your plot?
My lord, I have the plots are annexed as annexure P2, my lord. Page
On which plot this construction is being made?
several plots.
Which are the plots?
Several plots are affected, my lord. That is the reference is at
Page 24, my lord. He annexed the Khatiyans of the.
paragraph 10, my lord. Paragraph
10 of the writ petition.
Yes, my lord. Plot number 49, 76, 77 by 282.
You are the owner of these plots.
I have inherited these plots from my.
So you have become the owner of these plots by way of inheritance.
Yes.
No, along with other legal layer.
Yes.
All right.
Oh, that-
So
that's
he may be a part owner of this.
And also in paragraph 12.
Yes, which respondent will consider?
Okay, that is the difficulty.
District is,
And it's a state is heading, state is heading in this project.
You have to implement the district magistrate.
And district magistrate is, represent the state. So I have, and the state as a. Kindly, my lord, paragraph 4, kindly see the petition, read petition paragraph 4. The important violations of guideline 5.7, my lord. Paragraph 4.
Paragraph?
Paragraph 4, my lord.
At page 4.
At page 4. As per guideline 5.7, it is the responsibility of the state government to ensure that land required, if any, for the proposed right of way is available for taking of the process of upgradation of road. A certificate that land is available must accompany the proposal. It must be noted that PMGSI 3 doesn't provide any fund for land acquisition. However, this doesn't mean that acquisition cannot be done by the state government at its own cost. This is the guideline.
Where is your complaint dated 3rd of April 2025?
It is at page 18, 18.
1-8. Ashun, petitioner claims to be the owner of several plots of land. Claims to be the co-owner. You are the co-owner of several plots of land within Mouja,
RG Kakribadi.
within Mouja, RG Kakribadi,
And
under block Kuchbihar 2.
and another Moja.
Where is the other Mouja?
Pestajar. Uttar Pestajar. Difference is that page.
Follow page 19, paragraph 5.
No.
Page 19,
page-
paragraph.
Page 7 of the page.
Claims to be the owners of several plots of land within Mouja, RG Kakribadi, under Kuchbihar 2
And Uttar
and
Pestajar.
Mouja Uttor Pestarjhar
Same block.
under Kuchbihar 2 block in the district of Kuchbihar. Full stop. The petitioner alleges that the aforesaid plots that the plots of land owned by the petitioner as a co-owner thereof has been utilized for the purpose of widening
Upgrading a village road.
widening and upgrading the village road under Pradhan Mantri Gramin Sorok Yojana. Full stop. The petitioner claims to have submitted a representation dated 3rd of April 2025 before the district magistrate Kuchbihar. Full stop. The petitioner alleges that no steps have been taken by the concerned district magistrate pursuant to the no steps no communication has been made by the concerned district magistrate on the allegations made by the petitioner in the said representation. Full stop. The district magistrate Kuchbihar has not been implemented as a party respondent in this writ petition. Full stop. On the prayer of the petitioner, ব্র্যাকেটের মধ্যে appearing in person, leave is granted to the petitioner to implead the district magistrate Kuch Bihar as a party respondent in this writ petition. Full stop. Since the state is represented by its learned advocate, no fresh copy of the writ petition is required to be served upon the district magistrate Kuch Bihar. Full stop. The petitioner is directed to supply a copy of the amended cost title to the learned advocate for the respondent by within a period of on or before November 7, 2025. Full stop. The added district magistrate Kuch Bihar, being the added respondent, is directed to consider the representation. Really cool. Without entering into the merits of the claim made by the petitioner in the representation dated 3rd of April 2025, WPA number such and such stands disposed of by requesting the district magistrate Kuch Bihar, being the added respondent, to consider the representation of the petitioner dated 3rd of April 2025, which is annexed at page 18 of the writ petition, and to dispose of the same by passing a recent order which shall be duly communicated to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 6 weeks from the date of receipt of a server copy of this order, along with a copy of the representation dated 3rd of April 2025, which is annexed at page 18 of the writ petition. Full stop. Disposed of বলেছি তো।
My lord, I have shown certain, even illegal it is correction.
Let him consider these all illegalities you have ventilated. Yes, please amend. Yes, please assist him. Please assist him how to be implemented. Yes.
Lordship, I am Budusha, a super stockist of Messrs ITC Limited.
Yes.
And my premises are at Dal Singh Para in Alipurduar district. ITC has its premises at Matigara. Lordship, the subject matter is
case,
a
is
writ
it
of
item number 28?
certiorari before your lordship.
Yes.
And the certiorari is because a vexatious and vitiated criminal prosecution proceeding is pending before the AJCM. And lordship, I will explain how the
My lord,
proceeding is vitiated.
my lord, in this case, I am appearing on behalf of the respondent number 2 and 3.
Yes.
2 and 3, but I have to go through the entire read. Just today morning, I have been entrusted to appear. Only 2 days accommodation. I am praying for only 2 days accommodation. Thursday or Friday, any day.
All right.
I will appear physically
Lordship,
and make my submission.
I have traveled from Delhi. Lordship may just hear me for 5 minutes.
But he cannot assist because he has
Lordship,
got
yeah,
the.
they have been
No,
served.
no, no.
They have been served. He is admitting, but he has the council has received the papers only today in the morning.
Yes,
Lordship,
yes, only 2 days
I have
accommodation I am praying.
a very small request, Lordship.
Yes.
Thursday or Friday,
In the
any day, my
interim,
lord.
Lordship. Lordship, in the interim, the proceedings before the judicial magistrate may be kept in abeyance for whatever
No,
2-3
no, how,
weeks,
why?
whatever.
Without any hearing. I have to make my submission.
Lordship, the short case is that I have received goods from Messrs ITC Limited. Invoices, tax paid, have come to me. The goods have traveled by lorries which were engaged by Messrs ITC Limited. The allegation against me is that I have availed of input tax credit illegally for the reason that the goods did not get delivered to my premises. Regarding this, the CGST Commissionerate conducted its investigation not on actual movement of lorries, but on portal data. So the Central Board of Indirect Taxes and Customs has created a portal for monitoring e-way bills. And it is claimed that those e-way bills are aligned to the FASTag digital data, which is maintained by the NHAI. Now, the investigating team has stated in the application that they went through that data. They found that FASTag data was absent on that portal. So they presumed that these 232 consignments from Messrs. ITC Limited came to Dal Singh Para, did not come actually, because they did not cross the toll. There are two different routes. On one route, there are 3 toll gates. On another route, there are 2 toll gates. One toll gate need not be passed because very close by there is an alternate route and truck drivers try to save on the toll charges. So, but there is one toll gate which has to be necessarily crossed before the lorries reach Dal Singh Para. That data they did not inquire into. The petitioner was able to obtain that data, verified data of the FASTag digital data of the lorries, and has submitted to them. That they are not considering. The petitioner was arrested on alleged evasion of tax by availing input tax credit not admissible. The ground is you got only the tax paid invoices, but you did not get the goods. Now, I am the person who is receiving the goods. The transport has been engaged by ITC. ITC issues what are called loading notes or loading challans. On the loading challans, the lorry numbers are written. 2 copies of those loading challans are given to the lorry drivers. They bring the goods. It is not that every lorry driver is dedicated only to delivering at Buddhu Shastra. They deliver along the way. So there could be 2-3 other distributors, but the delivery has to be made only as per the delivery challan. Those delivery challans were received, the goods were received, and on the delivery challans, there is proof of delivery. I have got copies, original copies of the delivery challans. So, Lordship, the whole question is that I have availed of allegedly inadmissible input tax credit going to 37 crores. And the goods have not reached my premises. But then how am I able to produce 190 FASTag consignment data?
What is the order which you are challenging?
Lordship, this is the complaint which has been filed.
Complaint.
Page 189, Lordship.
189.
Page 189. The complete set has not been served, my lord.
Page 189, Lordship. If Lordship see, this is the criminal complaint.
$189. No, complete set has not been served, my lord. 189 বলছে।
Yes.
Now, Lordship, if Lordship sees in this, the premise taken is that these checks were made on the portal. I'll just show Lordship. Lordship, para 2. Para 2 is authorization, and para 3.4, Lordship. Lordship, para 3.4 and
Please,
para.
please give me a minute.
Yes.
Para
3.9.
3.9.
Yes.
Page.
Page 193.
Yes, I've got 193.
So para 3.9, Lordship, is to the effect that
93
it was only an online check. And presumably, it was presumed that all 332 consignments were not delivered. And the tax paid invoices are not disputed. Nowhere. And
Now, this is the complaint filed. Now,
yes,
what
this,
happened after this?
No, this is pending, Lordship, before the AJCM.
Yes, SEJM.
Lordship.
Yes.
Now, the license of the petitioner was cancelled on this basis that this investigation was undertaken by the CGST Commissionerate. Then they arrested him on the ground that you have evaded tax.
When he was arrested?
He was arrested on 31st of March.
31st of March.
Yes,
2025.
and
Yes.
Lordship, and he was granted bail by this honorable court on 17th of April.
All right. Now, what interim protection you want now?
The interim protection I want is that the criminal complaint, which is pending until my matter is heard, if that proceeds, again, I have been granted bail. I am free on bail, but the criminal complaint has been filed. The proceedings are vexatious, vitiated, and that is what I wish to explain.
That cannot be decided without affidavits.
I do agree, Lordship, but
so now,
let
these proceedings continue. Let these proceedings continue.
Lordship, charge sheet has been filed.
Yes.
No, but Lordship, there is a fundamental issue. Lordship may bear me for 1 minute.
Yes.
Lordship, the complaint says that my supplies are from ITC Limited, 232 consignment. Tax paid invoices are there for all 232. The transporters who delivered the goods, for which I have the proof of delivery notes, were engaged by ITC.
Now you want quashing of a charge sheet.
Yes.
So is it permissible under Article 226? What does the recent Supreme Court judgment say? Very recent Supreme Court judgment, quashing of charge sheet under Article 226. I think in the previous week it was.
Lordship, the cognizance is yet to be taken. But Lordship,
once a charge sheet has been submitted, it sees that under Article 226 it should not be interfered with. You take recourses under the before the criminal court for quashing of that charge sheet.
Lordship, the biggest flaw in this entire exercise is, and Lordship,
that cannot be considered. No interim protection can be passed.
No,
quashing, let them file affidavits, I will consider, or I can give you liberty to approach the appropriate SCJ court for necessary reliefs.
Lordship, just 1 minute. ITC is the supplier. I am the recipient. ITC has engaged the transport.
Pending.
The lorries have come. Now, no investigation.
Protection charge sheet cannot be quashed. First of all, whether a writ petition is maintainable or not, that is to be decided. Second, whether on this, under Article 226, it will be quashed or not. That's the secondary issue. That also cannot be decided without filing any affidavits. If you want, I can direct filing of the affidavits, keeping the point of maintainability open. That will be decided.
Lordship, that would be suitable, but there's just one point. The investigation has not moved even a millimeter to ITC.
That is a different thing. That
if my input tax credit is wrongly availed, who has paid the tax? There is no loss to revenue. And Lordship, on this very aspect, there is a decision of Suncraft. Now, Lordship, if Lordship may permit, para 6 and 8 of Suncraft, Lordship, just. Lordship, this, what I've submitted is the High Court order, and the SLP against this order was dismissed.
I know that because I was a party to this judgment.
I bow down to you, Lordship. Lordship, I just request para 678
678
of Suncraft.
Suncraft.
The ratio is at paragraph 8.
Yes, 678. Lordship.
Ultimate ratio
Yes,
is at paragraph.
yes, I bow down, Lordship. So, Lordship, in this
So-
case, all documents are submitted.
Is that to be decided, sir? How can it be this charge sheet can be quashed in that way?
Lordship, not on today's hearing. My very limited prayer is that let them file their affidavit, but till such time, Lordship, if the proceedings before the AJCM continue, then
Nothing
it will
will
defeat the purpose.
participate in that proceedings. Nothing will happen. Till now, cognizance has not been taken. Maybe the cognizance may not be taken.
Lordship, there's another aspect to it. This whole thing, why it is vitiated. So, Lordship, please see what kind of sanction has been given, mindless sanction, and I'll just demonstrate in a minute, Lordship. So, Lordship may see page 214 and sorry, 224 and 225.
Yes.
Now, Lordship,
page 224.
Yes. So, order for sanction of prosecution, order for authorization to file prosecution complaint.
Yes.
Lordship, now here, what the commissioner says is, when giving sanction, he says, who was arrested, I'm in the middle of the,
Yes, yes.
who was arrested under section 69(1) of the Central Goods and Services Act on 31/3/2025, being liable to punishment under provisions of 132(1) L. Now, Lordship, this is absolutely ambivalent. If Lordship see the statute, L has no punishment. L has 4 parts. 1, 2, 3, 4. The commissioner does not say on what offense, of which part. There's nothing. And then similarly,
it is best you can approach the ACJM for quashing up.
It is a matter of trial, my lord.
Best.
Lordship, my rights are affected, Lordship. That's why I have come to this court.
You can approach there. It's the best forum to decide on this. You can raise these points. I can give you liberty to approach that for quashing of that.
Lordship, the other aspect that I wish to submit is about the absurdity of the Bhajan Lal judgment of the Supreme Court. Lordship, popular.
There are judgments both sides.
But Lordship, what is
one line of judgment says yes, under Article 226, charge sheet can be quashed, criminal proceedings can be quashed. Other line of judgment says no, and that's the very recent judgment which says no. Under Article 226, it should not be done. So judgments are on both sides.
Lordship,
and Bhajan Lal is the parent judgment.
Lordship, my only submission is, Lordship.
Most of the judgments relying on Bhajan Lal take one view, other is taking another view on certain factual distinction.
No, Lordship,
so
that is,
those are to be considered.
That is why, Lordship, I requested attention to Suncraft. And there's another one, Lordship, Niranjan Paul. There also, Lordship. Lordship,
Yes.
Lordship, para 5 and para 9. This is precisely my case.
Next date.
Yes.
Now, Lordship, to sum up my argument, on 27th of July, I provided all information, including all evidence that is in my favor, which is digital, which is verified, not my own created. I have submitted that ITC has not been investigated. And Lordship, for this aspect, there is a board circulars, CBIC circular. Just take out. Lordship, the circular says that in case of illegal availment of input tax credit, the supplier has to be necessarily penalized. In this case, Lordship, that is totally absent.
Where is the order passed by the adjudicating authority?
There's no order. Lordship, this is a prosecution which has been launched after an arrest which had no legs to stand, no legal legs to stand. Now, Lordship, this is a circular which is binding upon the CGST authority. Lordship, the first part itself, this
Yes.
circular of Lordship, 9th July 2022.
9th or 6th?
Oh, sorry, 6th.
Yes.
Now, Lordship, if we just see serial number 1.
Yes.
In a case where a registered person A has issued tax invoice to another registered person B without any underlying supply of goods or services or both, whether such transaction will be covered as supply under Section 7 of CGST Act and whether any demand and recovery can be made from A in respect of the said transaction under the provisions of Section 73 or Section 74 of the CGST Act. Also, whether any penal action can be taken against registered person A in such cases. Lordship, the answer is, since there is only been an issuance of tax invoice by the registered person A to registered person B without underlying supply of goods or services or both, therefore, such an activity does not satisfy the criteria of supply. This is the allegation which they are making, as defined under Section 7 of the CGST Act. As there is no supply by A to B in respect of such tax invoice in terms of the provision Section 7 of the CGST Act, no tax liability arises against A for the said transaction. And accordingly, no demand and recovery is required to be made against A under the provisions of Section 73 or Section 74 of the CGST Act in respect of the same. Besides, no penal action under the provisions of Section 73 or Section 74 is required to be taken against A in respect of the said transaction. Now, Lordship, comes the most important part. The registered person A shall, however, be liable for penal action under Section 122(1)(2) of the CGST Act for issuing tax invoices without actual supply of goods or services of both. In my case, this has been violated. ITC has not been investigated. No allegation either in the criminal complaint or at the time of arrest, and no even questionnaire to ITC that you issued these invoices which were tax paid but goods were not found to be accompanying. What do you have to say? And this is a direction of the board, Lordship, to the CGST authority, that if such is the case, then the registered person A shall, however, be liable for penal action under Section 122(1)(2) of the CGST Act for issuing tax invoices without actual supply of goods or services or both. It has not happened. So, Lord,
no action taken against ITC.
Nothing. No allegation, nothing. So, Lordship, I am being prosecuted with one eye closed. Lordship, also, my returns are all filed. What Lordship have already explained in the Suncraft decision. As far as my returns are concerned, they're all filed. The goods and the tax paid credit is all reported. It has been reported regularly. There's nothing.
And documents with regard to movement of the goods are also there.
Yes. And I just showed Lordship, they have only gone to a portal portal of the CBIC itself, saying that on this data, with e-way bill, you can also track the FASTag, which is not there. They just said there was no. If that was the case, how did we get? And the most interesting part of this is, Lordship, on 27th of July, we filed the entire data. On 6th of August, the charge sheet has been mindlessly filed without considering that data. And as far as launching of prosecution is concerned, there's another board circular. That circular, Lordship, says that where the that circular, Lordship, says that where a person has been arrested, the charge sheet shall be filed within 60 days. But where a person has been arrested and granted bail, then the proposal for sanction of prosecution shall reach the commissioner or principal commissioner within 50 days.
Where is that?
Lordship.
That has also been violated.
Yes. If Lordships come
which
para
paragraph?
7.1.1 of the circular, page 3.
7.1.1. Yes.
So, Lordship, in the middle of the para, it says, where during the course of investigation, arrests have been made and no bail has been granted. All efforts should be made to file prosecution complaint in the court within 60 days of arrest. In all other cases of arrest, prosecution complaint should also be filed within a definite time frame. The proposal of filing complaint in the format of investigation report prescribed in Annexure 1. So there is an Annexure 1 at the back. Should be forwarded to the principal commissioner within 50 days. Now, Lordship, in this case, the bail was granted on 17th of April.
17th of April.
Yes, Lordship.
And 17th of April 2025 bail was granted.
Yes.
And this
prosecution has been filed on 6th of August. Sanction for prosecution has been granted on 17th of July.
So according to you, so there has also been violation. It
Yes.
has to be within 50 days.
It is mandated, Lordship.
50 days of arrest.
50 days of arrest.
Not releasing of bail.
No. 60 days where no bail is granted.
Yes.
But 50 days from the date when bail is granted.
50 days of arrest. It does not say.
Oh, sorry. 50 days of arrest.
Says 50 days of arrest, not from bail.
50 days of arrest.
So in a case where bail has been granted, so it has to be from the 50 days from the date of arrest.
Like, and so 31st March was the date of arrest, 30th April and 20th May. By 20th May, the proposal should reach the commissioner or principal commissioner for sanction of prosecution.
Yes. Yes, Mr. Ponik.
My lord, first of all, the complete set of document has not been served. Number one. Moreover, so far submission of my learned friend, he submits that section 132 subclause 1 has been violated. My lord, in this case, I am the concerned counsel conducting the case before the ACJM. From the document, I can show that there was no violation, and regarding sanction of the chief commissioner, principal commissioner and commissioner, sanction has been obtained within the stipulated period. Moreover, by filing this writ petition, the quashing cannot be possible. My lord, there is another writ petition that is 1708/25 is also pending.
Lordship,
1708
is
of
on a different
25
cause of action. That is not on this.
is also pending with respect to same cause of action.
Self
My
same
lord,
cause of action.
Different
yes,
cause of action.
What is the cause of action there?
1708 of 25,
Yes.
wherein direction was Honorable Justice Rajabasu Chaudhuri, direction has been granted for exchange of affidavits. It is mentioned in serial number 7. My lord, charge sheet has been filed
Lordship,
on
it is
6th
annexed.
August, but they have not received the copy of charge sheet intentionally and avoiding the process. The matter is pending before the learned SCGM Shiliguri, and so, my lord, I have allow me to file my affidavit in opposition, and before that, give them a direction to furnish all the documents which they have not filed, not submitted before the authority also. Another point is, my lord, just now I received a call wherefrom I found that the adjudication proceeding has already been started. My lord, adjudication proceeding with this case has already been started. This is a criminal proceeding. This is a separate proceeding. And as per section 132,
That has been initiated.
Lordship.
yes, adjudication proceeding has been initiated. Notice was issued upon the SSC, and they have not yet filed their reply. And this is a separate proceeding, criminal proceeding, as per
Yes,
section
yes.
132 of
Yes, yes,
CGST
paid
Act.
for quashing of that criminal proceedings in
No,
this writ petition.
Yes, that is what we have
Ye-
paid.
Yes, my
Lordship,
lord, they
just
have not
one
filed
small
any
aspect.
application before
Yes.
before
About
the
the
SCJM also.
vexatious nature
They have not
of this
received the
proceeding.
copy of charge
Lordship, if
sheet.
Lordships can come to page 64 of
So
the
my
petition.
humble submission, give me an opportunity to file affidavit in opposition.
Lordship, page 64.
I will bring all the facts and circumstances before this court together with the
Yes.
Yes.
document.
Lordship, this is the arrest authorization order given by the commissioner. If Lordship see, it's in very small this thing, but I'll read out what it is. The saying is that section 132 1 L.
I1.
One.
I. Read with 132 1C.
Yes. But Lordship, if Lordship sees section 69, Lordship. Section 69, it reads, where the commissioner has reason to believe that a person has committed any offense specified in clause A or clause B or clause C or clause D of subsection 1 of section 132, which is punishable under clause I or II of subsection. Now, Lordship, the satisfaction is not recorded. It is just, okay, I hereby authorize, go and arrest. What offense? A,
My
B,
lord,
C.
kindly fix it Thursday.
Punishable
I
under
will,
what?
appear physically, I will make my
You have
submission.
obtained a bail. You are arrested. You have obtained a bail.
What I'm
So,
Lordship,
yes,
the criminal
that is separate
prosecution
proceeding.
is a follow-up of that. I showed Lordship on page 224, 225.
Yes.
There also, if Lordship see, it is total non-application of mine. Lordship, this is a tax statute. We cannot imply anything. It has to be read strictly. And if Lordship see what they are saying in this, here it is saying 132, 1L. And
is it L or 1?
1.
Not
So
L.
even if we read 1, Lordship,
Yes.
the
My
offense
lord,
and the
JK
punishment
has
is
been
not
omitted and
specified.
L
If
is
this is
inserted.
the application of mind, Lordship,
Sir?
if this is the reason to believe, if Lordship see section 132, please. So 132, Lordship, says 132.1, punishment for certain offenses. Now, whoever commits or causes to commit and retain the benefits arising out of any of the following offenses. So the offenses, Lordship, are listed out in A onwards. Then, Lordship, comes L. Attempts to commit or abet the commission of any of the offenses mentioned.
L, this is I.
No, Lordship.
I.
Lordship, HI and then L, because
Not L. The violation is 132.1I. Please read I. I tallies in this.
Lordship, I is there even above HI. Please see, Lordship.
Yes.
So the whole thing is,
what does I say?
Yes. In cases where the amount of tax evaded or the amount of input tax credit wrongly availed or utilized or the amount of refund wrongly taken exceeds. Receives or is in any way concerned with the supply of or.
So this is on the recipient.
Yes. Like
Connected
Lordship.
with the supply of.
Lordship. But what is required.
Or in any manner deals with the supply of service which he knows or has reasons to believe are in contravention of any of the provisions of the Act.
Yes.
On the recipient and supply.
But Lordship, the interesting thing is the criminal complaint does not talk.
This is
criminal complaint talks of 132, 1B and C. So the sanction given and the basis of the sanction as in the criminal complaint is entirely different. I'll just show, Lordship. Lordship, may please come to page 219.
My lord, entire set has not been supplied. I am not in a position to reply.
In clause B, or fraudulently avails input tax credit without any invoice or bill.
So, Lordship has already got what I'm trying to convey. The commissioner has not applied his mind what A, B or C or together B and C. He has simply given a blanket sanction for prosecution, saying 132, 1. Now, the offense is listed in B and C. And this is what is there on page 219. So, yes. Sanction is abbreviated. The criminal complaint expands it beyond the sanction. Lordship, these are the things. And on this way, and ITC,
no action has been taken against the IC.
In fact, Lordship, my learned friend should be asked about.
The petitioner.
My lord, I'll make my submission on Thursday. He has not supplied all the documents, my lord. All the copy of documents.
Has prayed for quashing of the criminal proceedings in connection with CR case number 530 of 2025 arising out of the complaint dated April 1, 2025 filed by the Superintendent Jalpaiguri CGST and Central Excise Commissionerate and the subsequent charge sheet dated August 6, 2025. For alleged offence punishable under section 132 within bracket with 1 within bracket small b, comma 132 1c bracketed মধ্যে, comma 132 1i and 132 5 of the CGST Act 2017, which is presently pending before the learned Additional Chief Judicial Magistrate, Shiliguri. First up, the petitioner has also prayed for a declaration that the arrest of the petitioner on March 30, 2025 as illegal, unlawful, and without jurisdiction. Full stop. The learned senior advocate appearing for the petitioner submits that there has been gross violation of the clarification made by circular dated July 6, 2022, issued by the Government of India, Ministry of Finance, Department of Revenue, Central Board of Indirect Taxes and Customs, wherein under serial number 1, wherein with regard to the issues raised under serial number 1 of the said memo, it has been stated that the registered person shall, however, be liable. The registered person who has issued the tax invoice to the another registered person without any underlying supply of goods or services or both shall be liable for penal action under section 122 within bracket 1 within bracket II of the CGST Act for issuing tax invoices without actual supply of goods or services or both. The learned advocate submits that the registered that ITC is the registered person who has issued the tax invoice to the petitioner, and in view of the clarification under serial number 1, a penal action ought to have been initiated against the ITC Limited instead of against the petitioner. Full stop. The learned advocate further submits that the guidelines for launching of prosecution under the Central Goods and Services Tax Act 2017 under instruction number 4/2022-23 dated 1st September 2022. কি বললাম? More particularly, subparagraph 7.1.1 has been violated, as the prosecution complaint was not filed within the time frame indicated in the said instructions. Full stop. Paragraph. Mr. Bonik, learned advocate representing the CGST authority, prays for time to make appropriate submissions with regard to the in reply to the submissions made by the learned advocate for the petitioner. Full stop. He questions he raised an objection against the maintainability of an application under Article 226 of the Constitution of India, praying for quashing of a charge sheet submitted before the concerned ACJM. He submits that an adjudication process has already started and the petitioner has not filed any reply in the said adjudication process. Paragraph. Such submission is, however, disputed by the learned senior advocate appearing for the petitioner, who submits that the petitioner is contesting the adjudication process. However, paragraph. However, since various legal and factual issues have been raised in this writ petition, and an objection against maintainability of the writ petition has been raised, this court is inclined. This court feels that an opportunity should be granted to the respondents to file their affidavits, in opposition. Let affidavit in opposition be filed within a period of
4 weeks, my lord. 4 weeks.
Why 4 weeks?
Voluminous document, my lord.
Within a period of 4 weeks from date, reply thereto, semicolon, reply thereto, if any, be filed within a period of 2 weeks. 2 weeks thereafter, full stop. Parties will be at liberty to mention this matter for enlistment under the heading hearing after the period fixed for exchange, after expiry of the period fixed for exchange of affidavits. Full stop. The question of maintainability of the writ petition is kept open to be decided at the time of final hearing of this.
Lordship, just one sentence where Lordship talked about para 7.1.1, just one sentence. The proposal for sanction of prosecution was not placed before the commissioner within the prescribed 50.
I've said in violation of that time frame.
Yes.
Lordship have said for
There was
filing
no-
of
no
prosecution
violation.
complaint.
The learned advocate further submits that the procedure for filing of the prosecution complaint was also
The procedure for seeking prosecution sanction within
the
50 days.
procedure for seeking the sanction for prosecution
Within 50
was
days.
within the prescribed period was also not followed.
Grateful, Lordship.
Thank you.
Grateful.
হ্যাঁ বলুন বলুন হয়ে গেছে